nothing worse when you're doing your closing argument and you feel like you're in the zone and somebody comes into the room or somebody's cell phone goes off. That throws everyone off. For the attorneys, what I can tell you is we have one juror that we're waiting on. So we're going to see if that juror is here. So if you have someone who is on bond, it will be easy for us to take care of that. But if they're in custody, we're going to have you come back later after they finish closing arguments. And what I can tell you is each side has 20 minutes for closing arguments, so you can do your calculations. All right, Robert Christopher Perez. All right, thank you. Jose Martinez Cardenas. Brian Adams Sanchez. Thank you. Ruben Apreciado. James Francis. Joseph Gilbert Montez Lee. Just one second. Lori
hair.
Valdez.
Green hair outside.
All right, are all the jurors here?
No, Your Honor.
All right, so then everyone, if you'll please confer on your bond cases. If there is a bond matter, we may be able to take it up. If it is a case where your client is in custody, we can't bring them out right now. Okay, Carly Simon, yes. And I'm trying to think of which movie it's from. Because I remember the song, it's like, you'll be coming around again. Oh. Hello, good morning. Good morning. Well, I let you all do the calculation. It's probably going to take me maybe 15 minutes to read this charge, maybe less. And then each side is going to have exactly 20 minutes. So I would say, well, you know, I used to be great at math, wanted scholarship in math. And then you become attorney, it all goes out. People can say, oh, well, they paid $20 and then they paid $25. And I'm like, so I tell you what, I would say come back at 10:45. Yeah. Oh, are they all here?
Yes, Judge.
All right.
Lined up, they're ready to go.
Court is calling 2023 CR 10004 State versus Tyler Ashbaugh. Can I have parties announced?
Nathaniel Navy and William Salazar for Mr. Ashbaugh.
And you're Mr. Ashbaugh? All right, so yesterday we did have a charge conference, and my understanding is there is no objections to the charge as presented. Is that correct, State?
Yes, Your Honor.
Defense?
There was, Judge, but I just dictated those to the court reporter yesterday. I don't have any additional objections.
All right. And were those dictations, was that arguments that the court had previously heard? Or was that something new?
That was something new, Judge, but you already ruled and you denied my request.
Well, I mean, if you're putting something new on the record that you haven't presented to the court, then the court needs to hear it so the court can make a ruling. Otherwise,
Maybe I'm misunderstanding, Judge. It's nothing new since yesterday, if that makes sense.
All right, so let's do this. What are your objections?
It was to the voluntary intoxication charge, Judge,
All right, so,
which you've already heard.
okay, all right, thank you. We were crossing it on the communication path. All right, let's, before we do that, does anyone need time announcements?
Judge, we're gonna split. If Mr. Salazar could get a 1-minute time warning, he's just gonna start with a 3-minute. And then for me, if I could get a 3-minute warning for the remainder of that 20 minutes.
All right, now are you all splitting your time?
Yeah.
Oh, need time.
Okay.
6 to 10 minutes, so make him sit down.
Okay. Well, you'll need to look at him and say,
We need time, 19 minutes, please.
all right. All right, everyone, please rise.
All right, so jury.
All right, everyone, please be seated. All right, ladies and gentlemen, you have heard all the evidence that you're going to hear. What I'm going to do is I'm going to read to you what's called the charge of the court. You do not have to memorize it because you will be given this original back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Tyler Ashbaugh, stands charged in counts 1 and 2 of the indictment with the offenses of aggravated assault against a public servant alleged to have been committed on or about the 22nd day of May 2022 in Bexar County, Texas. The defendant, Tyler Ashbaugh, stands charged in count 3 of the indictment with the offense of deadly conduct alleged to have been committed on or about the 22nd day of May 2022 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of assault if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. A person commits the offense of aggravated assault against a public servant if the person commits an aggravated assault as defined above against a person the actor knows is a public servant while the public servant is lawfully discharging an official duty or in retaliation or on account of an exercise of official power or performance of an official duty as a public servant. 2, our law provides that a person commits the offense of deadly conduct if he knowingly discharges a firearm at or in the direction of one or more individuals or a vehicle and is reckless as to whether the vehicle is occupied. 3, bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion of burning substance or any device readily convertible to that use. Public servant means an officer, employee, or agent of government. Peace officer includes sheriffs, deputies, constables, deputy constables, marshals, or police officers of an incorporated city, town, or village. Vehicle includes any device in, on, or by which any person or property is or may be propelled, moved, or drawn in the normal course of commerce or transportation, except such devices as are classified as habitation. 4, A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to the circumstance surrounding his conduct when he is aware of but consciously disregards of substantial and unjustifiable risks that the circumstances exist. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 5, you're instructed that under our law, voluntary intoxication does not constitute a defense to the commission of a crime. For the purpose of this law, intoxication means a disturbance of mental or physical capacity resulting from the voluntary introduction of any substance into the body. The state must prove all elements of the offense charged beyond a reasonable doubt. 6, count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of May 2022 in Bexar County, Texas, the defendant, Tyler Ashbaugh, did use or exhibit a deadly weapon, namely a firearm, and Tyler Ashbaugh did intentionally or knowingly threaten imminent bodily injury to P. Jaimes by shooting at or in the direction of P. Jaimes with said deadly weapon, and Tyler Ashbaugh knew P. Jaimes was a public servant, namely a peace officer, while P. Jaimes was lawfully discharging an official duty as a public servant or in retaliation or on account of P. Jaimes's exercise of official power or performance of an official duty as a public servant, then you will find the defendant, Tyler Ashbaugh, guilty of the offense of aggravated assault against a public servant as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1. 7, count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of May 2022 in Bexar County, Texas, the defendant, Tyler Ashbaugh, did use or exhibit a deadly weapon, namely a firearm, and Tyler Ashbaugh did intentionally or knowingly threaten imminent bodily injury to R. Acuna by shooting at or in the direction of R. Acuna with said deadly weapon, and Tyler Ashbaugh knew R. Acuna was a public servant, namely a peace officer, while R. Acuna was lawfully discharging an official duty as a public servant, or in retaliation or on account of R. Acuna's exercise of official power or performance of an official duty as a public servant, then you will find the defendant, Tyler Ashbaugh, guilty of the offense of aggravated assault against a public servant as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. 8, count 3, paragraph A. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 22nd day of May 2022 in Bexar County, Texas, the defendant, Tyler Ashbaugh, did knowingly discharge a firearm at or in the direction of a vehicle, and Tyler Ashbaugh was reckless as to whether the vehicle was occupied, in that Tyler Ashbaugh failed to make adequate inspection or inquiry regarding the presence of others therein, then you will find the defendant, Tyler Ashbaugh, guilty of the offense of deadly conduct as charged in count 3, paragraph A of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3, paragraph A. 9, count 3, paragraph B. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 22nd day of May 2022 in Bexar County, Texas, the defendant, Tyler Ashbaugh, did knowingly discharge a firearm at or in the direction of individuals, namely P. Jaimes and or R. Acuna, then you will find the defendant, Tyler Ashbaugh, guilty of the offense of deadly conduct as charged in count 3, paragraph B of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3, paragraph B. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messages service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor tendered in evidence. I can only send statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 11 of you must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by all jurors. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written and prepared by the presiding juror and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. Are parties ready to proceed with opening statements?
Please raise your.
And defense, will you be ready?
Yes, Judge, ready. Closing arguments.
All right. So ladies and gentlemen, I know that you noticed that there's a crowded courtroom today. They are not involved in any way in this case. I have morning dockets. So this is something completely separate from this. So please disregard. All right, State, are you ready?
Yes, ma'am. Ms. Gelsels. Ladies and gentlemen, I'll be speaking to you briefly, and then defense counsels will have an opportunity to speak with you about the case and their views on it. And then also Megan Galloway will be the summation of the closing arguments for this case. And then you will receive the charge, go back to the deliberation rooms and begin deliberating at that point. Remember this, that as the judge said, in this charge is the stated law that you have to follow, that you took that oath. You'll take this charge back to the back. You'll have that copy. You'll have an opportunity to look at it, review it. So don't feel like you had to memorize everything that the judge just said, because it's a lot of stuff in there. I'm going to go over the charge with you. The definitions and the law that abides by this case is in here. What I'm going to go through is talk about one on paragraph 5 and page 5. It talks about voluntary intoxication. There's been a lot of talk about intoxication of this individual. He's already stated he was highly intoxicated by alcohol and marijuana, that he drank at work, he drank after work, he drank at the bar, he drank at Harold's, and he smoked marijuana the whole time. All voluntary. He admitted that on the stand. He cannot use that as a crutch. He cannot use that as a defense.
Judge, I'm going to object to being an improper argument and a misstatement of the law. That instruction is just saying it's not an affirmative defense, meaning that the jury considers that only if they believe all elements have been proven beyond a reasonable doubt. And we've never made that argument in this case, Judge.
All right, objection is overruled. You may proceed.
Thank you, Judge. He cannot use that as a defense.
I'm gonna
Now,
object again, Judge.
Overruled.
moving through the charge, it'll have count 1, which speaks of, and count 1 and count 2 are exactly the same except for the victim, okay? Jaimez and Acuna. Those individuals are police officers. Now, the elements of these cases, you heard Darren Bordier, the date, the county, the defendant. Those are without question are proven. I mean, the defendant got on the stand and admitted that he's the person. Also, another thing that's not even in question is a deadly weapon, the firearm. He admits that it's that he shot that deadly weapon. So none of that is in question. That is not in question at all. What defense counsel most likely will argue is, one, about whether police officers, that he knew was a public servant and a police officer, that patrol car in particular, because those 2 officers were in that patrol car, got all those decals in this dark parking lot that is obviously lit up. And through their own photograph that they took at night, you can see the vehicle of the investigator, the private investigator that they hired. You can see the reflection of that car in that picture without any decals, without any reflectors on it. So keep that in mind, that the fact is that this individual knew that was a police vehicle, drove down there and shot at these individuals, or at least in the direction of those officers. You heard the testimony of each of those officers that they saw the flashes of that muzzle coming to shooting towards them. You have to disbelieve them and believe him. Disbelieve two officers that are sober, that are patrolling our streets. Disbelieve them over him. Now, that's count one and count two. That's aggravated assault on a public servant. Now, count three has two paragraphs. You have two choices. One was with the vehicle, where you knowingly discharge a firearm in or at or in the direction of a vehicle. Notice it just says the vehicle, that he's reckless of whether that vehicle was occupied. Notice also in this count, there's nothing mentioning of any person for that matter, except for the occupants of that vehicle. But also on top of that, it doesn't mention anything about police officers or public servants. So that element is not in count three, that these individuals were police officers, or that he knew that these individuals were police officers. Just that he shot in, at or in the direction of that vehicle. Keep that in mind. And he's reckless of whether it was occupied. That's paragraph A of count three. Count three, paragraph B is shooting at or in the direction of two individuals, Jaime's and Acuna, or Acuna, either one, or both of them. Again, one of the elements that's not in that part of the counts, and that count, is that these individuals were public servants or that they were police officers. So that element is not in count three at all. Our state's position is that all these counts have been met. No doubt that every element has been proven beyond a reasonable doubt. If you believe the officers. If you don't believe the officers, come back not guilty. If you think they're lying, come back here and say not guilty. We can accept that. That's fine. Because that states that you believe this individual over here. A self-admitted liar. A self-admitted individual that stated, I was trying to talk my way out of it. He was trying to talk his way out of it because at the time that he was speaking to the detective, he didn't know the amount of evidence that they had against him. In fact, the detective didn't even know the amount of evidence that he had against him. They had the vehicle. They had, later on, they had ballistics. Shell casings from that car matched the shell casings at the scene, that matched the gun that is found where? In this individual's possession. Which he says, again, lying, I never shot that weapon, ever. You heard that testimony, self-serving. You heard all these lies over and over. And then you heard him on the stand yesterday, right up here, when he stated, after reviewing all the videos, the reports, then, and only then, did he come up with a better story.
Objection, facts not in evidence, Judge. That's not what he testified to.
All right, ladies and gentlemen, you remember the evidence as it was presented to you?
May I proceed, John?
Yes.
You heard what he said on the stand. All of a sudden, hey, ballistics. We got the DNA. Matches his. From the gear shift and the door handle. We got a fingerprint on the rearview mirror. The car is in his father's parking spot or his driveway, perfectly parked. We have Harold's statement that doesn't really mesh well with his statement that he gave. We got Tatiana, his girlfriend at the time, now his wife. Her statement. She also states, and he states that he makes some stupid decisions when he's drunk. You have all this evidence put together, text messages, data from the cell phone, pointing at him, directing it at him. Now, 3 years later, he comes in and testifies. It says, oh, I was lying because I was in a mentally bad place. My coworkers were after me. My dad was being mean to me. My girlfriend, my wife, my mother of my child was being mean to me. Everybody's mean to me, but I carry a gun right here, go to work, drink to my fill where I'm highly intoxicated. I can't remember if I had my eyeglasses that I have to see, and I'm driving around, not hitting anything except for, well, a curb after he's shot at because he shot at police officers.
12 minutes remaining.
Thank you. So when it comes down to it, ladies and gentlemen, he's Monday morning quarterbacking this. He knows that we had a mountain of evidence against him. And so he wants to be like, okay, wait. I follow this other story. Make this one up. And I know they have all this evidence. All to say I did it, but I didn't mean to do it. I didn't know those were officers. I didn't know that car was there. I didn't know they were police officers. Then it makes a little bit more sense. It's like his story fits after he sees all the evidence, after he has the opportunity to see it all. The story changed from back when he visited to the detective to now. It changed. Lots. He's trying to talk his way out of it. And this phase of the trial is not about his freedom. It's about justice. The freedoms aspect comes in the second phase of this trial, if there's a guilty. That's when you determine if he goes to prison or if he has probation. That's that phase. That's not this phase. This phase is determine justice for our community, justice to not have some individual high on marijuana, high on and alcohol, driving around our streets, taking pot shots at officers, a plea for law enforcement. Don't believe him. Believe the officers. The evidence shows that. Thank you, ladies and gentlemen. I'll reserve time for my co-counsel.
Right, defense.
Please the court, state.
You can wait on that. He's gonna go first. Thank you.
Morning. This case comes down to perspective. And only when you put them all together and you begin to have a clear picture of the series of bizarre events that took place. Now, when you look at the facts available to Officers Jaime and Acuna, it's easy to understand why they thought shots were fired at them at the time that Tyler fired the shots out of his window. Having just come from an aggravated assault case, parked in a parking lot by themselves, a vehicle matching the description of a suspect in that prior ag assault case comes rolling up on them in the middle of the night. During those fleeting seconds that Officer Jaimez had to make a decision and process the information during those fleeting seconds through that lens, it's understandable that in those moments, Officer Jaime may not have noticed every detail, but it's important to look at the details he does remember with the facts that we have now. From his view, he testified he couldn't see the muzzle, and it looked like it was aimed more towards Roland's side of the vehicle, Officer Acuna. Now, this would suggest that the firearm was not parallel with the vehicle, which from the testimony that we heard from Detective Tudor would have been required to fire directly at the patrol vehicle. Now, Officer Jaime has also testified that when he saw the shots fired, he attempted to draw across his lap and shoot through the windshield. And he compared the two vehicles to jousting. We heard from Detective Tudor that of the possible ways that Tyler could have tried to fire a shot at the patrol vehicle, one would have to either lean out of the window and cock the wrist or shoot through the windshield. Now, the photos of the Nissan Rogue, there are no bullet holes in that windshield. And from Officer Jaimes and Acuña's testimony, they did not see anyone leaning out of the vehicle. Only not even the muzzle of the firearm itself. The state took time to point out the muzzle flashes in the church video, State's Exhibit 111, and the last one in particular at 02:02:01 a.m. But it's important to note that that would have been the fourth gunshot fired. The first was Tyler, the first after Tyler's only three. Detective Tudor testified the first shot took place at 02:01:59, followed immediately by two more. Therefore, it would have been
3 minutes.
Officer Jaimes' gun firing when the vehicles were parallel, not Tyler's
3 minutes have expired.
at this closest point. The photos you've seen of the patrol vehicle referred affectionately by Officer Jaimes as black and whites demonstrate the front of the vehicle is all black and no white and contains the smallest amount of reflective material of any of the sides of the vehicle. Tyler couldn't see a car was even there, let alone that it was a marked patrol vehicle with two officers inside. Is it unreasonable to believe that a patrol vehicle that was attempting to make itself hard to be seen was successful in doing so? I don't think so. For count 3, the indictment reads that in order to find Tyler guilty of deadly conduct, you have to believe beyond a reasonable doubt that Tyler knowingly discharged his firearm in the direction of a vehicle, as in he knew he was discharging his firearm in the direction of a vehicle, as in he knew that vehicle was there. Ladies and gentlemen, the evidence is overwhelming that Tyler never knew that vehicle was there. In count 3, you need to know, Tyler would need to know that there are two people in that vehicle that he can't even see. We now have the benefit of having all these facts available to us and all the time needed to look at this case through a more complete lens. It's not enough for the officers to believe that their lives are in danger. You have to believe beyond a reasonable doubt that it was Tyler's conscious objective that he knowingly shot at police officers and he was aware they were there. I'll see the rest of my time, Mr. Name.
All right, you have 15 minutes.
Thank you, Judge. If you could just give me a second to set up.
Yes, I'll pause your time.
All right, may I proceed, Judge?
Yes.
Thank you. May I please report, counsel? Good morning, ladies and gentlemen. Now you've seen all the facts, all the ingredients, all those conditions that put that perfect storm in motion that I discussed during opening statements. That perfect storm that lands Tyler Ashbaugh, innocent of what he's accused of doing, here possibly facing the rest of his life in prison. You heard that he was drinking heavily. 2 bottles of brandy at work, 300 plus milliliters each. The officer or detective that processed that scene said it was 325 or 375. And so 300 milliliters is roughly 7 shots. So each bottle of that is more than that. 2 24-ounce beers, more beers at Harold's place, and then shots. He couldn't remember how many at the 2 Rivers. He just remembered that he had a double shot before last call. Now, I want to discuss with you the jury instruction, this voluntary intoxication, what it is and what it is not, what it means and what it does not. You can only consider this if you believe all elements have been met beyond a reasonable doubt. That includes that Tyler intentionally and knowingly threatened imminent bodily injury. So this is it. All this instruction is saying is essentially that this is not an excuse. And we've never argued that. Only if you believe that he was guilty of beyond a reasonable doubt of these charges, getting drunk was not an excuse to do that. We've never argued that to you. So what it is not, it's not a substitute for the mental states you still have to believe beyond a reasonable doubt. You still have to believe that he knowingly did this, that he intentionally did this. And intoxication is 100% allowed to be considered as a factor in deciding whether he could have seen the police, their vehicle, or whether other elements of the offense what was met. So you've seen his ID. He has that Class A restriction. What that means is that he cannot operate a vehicle without corrective lenses. And you see that, it states that on the back of his license. You heard from his eye doctor that he has myopia bilateral. What that means is he has trouble seeing things at a distance. And she described in great detail what that means. He has an astigmatism. That makes it even more difficult seeing things at night. And you even saw in the state's own demonstrative exhibit that even with the astigmatism, like the lights are thinner, they're harder to see. He's nearsighted, trouble seeing things at a distance, described that to you. The doctor said no, in response to the state's questioning, he should not be operating a vehicle at night. And so where was the police vehicle? A great distance from that entrance to the church. It was, Officer Hyman's testified, it was blacked out. It has a black front. And even in Tyler's statement to Detective Tudor, he's just volunteering this. This isn't any sort of like lie he's concocting. He's just like, you know where you are. I'm sorry, I just can't see very well, but I think I'm downtown at San Antonio Police Headquarters. And then we have evidence that he's not wearing his corrective eyewear. So Tyler even testifies to you now, I don't remember. It would be better for him to just, if he was just trying to concoct a lie in court, to say, no, I remember I wasn't wearing my glasses. He says, I don't know, but look what we found that was never collected as evidence. That eyeglass that is exactly like the eyeglasses that Tyler has always worn is sitting there on the floorboard of that Nissan Rogue. And then Tatiana testified that in the jail call she had with Tyler, right after he was arrested.
Referring to facts not in evidence, there's no evidence in the jail call.
Well, she testified that this was her statement, Judge.
Ladies and gentlemen, you will remember the evidence as you've heard the evidence.
And she stated, I still have not found your glasses lens. Harold said you got into his car without it. And I know that his father was, yeah, this could have been mine. It might not be. I trust you to look at that for yourself. Is that rectangular or does that appear round? And also, his dad's complaining about the vehicle. He also would have been complaining if he didn't have his glasses for a week, in addition to not having his vehicle. He would have been blowing Tyler up about that. Yeah, and I already discussed that with you. Okay, so let's look at Tyler's 3 shots, and we don't see the police unit in this video. Well, and once again, I think the audio is a little bit different on the court audio, because it has to go through the computer and all the way here. But look at the exhibit, and you've already heard that in court. Look at it for yourselves when you get back there. And Detective Tudor and Christopher Otero both testified that at the location of the 3rd shot, that vehicle is a little bit protruding from behind that column, and we don't see that police unit yet. So trying to estimate the location of the last shot, this was testified to by Detective Tudor as well as Christopher Otero, the investigator for the defense. The bumper of the road is still visible behind that last pillar. You can look from the angle of that camera. The police units is not visible. It's behind that building. And the dash, the officers agreed it has branches in that upper corner. And then his first shot appears a lot further back before he's even reached that curb line, which is significantly further. And the police unit is all the way up that hill, blacked out with its lights out. And so you can compare the exhibits that the defense admitted. This one over here is the one on the left is the dash cam of the police unit. And then this one is the one that vetoed. I would argue, if anything, we actually probably parked that a little bit closer. You can see the distance to that building over there on the right. You can see where the lights are. The one in the police unit looks actually like it's a little bit further back than where we parked. So we're not trying to hide anything. We're not trying to make this inaccurate for you. We're just trying to assist you with this investigation. Already discussed that. Okay, and consider Detective Tudor's testimony. He agreed to that location of the first shot and the last shot. Consider that distance. Look at Mr. Otero's video from perspective. You can see that parking lot, how long that parking lot is, how far up it goes, how far up that hill that goes. Consider all that. And then there's very strong evidence that Tyler fired the gun with his right hand. That is going to be critical to this case. He's right-handed. He testified to that. He also told the gunshot residue person that he was right-handed. And there's only gunshot residue detected on his right hand, not on his left hand. That would indicate he's firing the gun with his right hand. And in order to do that, if you're the driver of a vehicle, you can't just reach it out and shoot like this with your left. You have to pull it all the way over your body. You have a lot less distance. If you can reach it out, maybe you could shoot right here into the ground. But if you want to shoot somebody that's in front of you, you have to snake your wrist at a really weird, uncomfortable angle where you have no stability. And Detective Tudor testified from the locations of those shots, yeah, you probably have to shoot through the windshield. And he testified to the dangers of shooting with that weak, unsupported wrist, it could misfire. And anybody that's fired firearms, that could just fly out of your hand if it's over here, way to the right. In that really weird, uncomfortable position. And the first two shots are even further back than what I discussed. Okay, the darkness. There's no moon, there's no stars in any of these videos. The only occasional light is from the flash of lightning behind the cloud cover. That indicates there's also cloud cover, making it darker than it otherwise would have normally been. And so you see, these are their own evidence that comes from the state. And this one, you can see Officer Akumi, the right side of him in this, which is his left side, just kind of blends into the darkness right there. And then the photographs of the stills that we admitted after that police unit rolled down that hill, they retrieved it and they parked it facing it. If you want to watch the rest of that dash video, you'll see when they're looking for shells, they just kind of come in and out of sight. They kind of disappear in the darkness. They're using their flashlights too. If this church is so bright, why do they need to use their flashlights to look for these shells? Why can't they just see it if it's as bright as they want you to believe it is? And these photographs they're taken by a San Antonio police officer, San Antonio police. These are more effective than any argument I could ever make, okay? They say a picture is worth 1,000 words. Same thing. You can't even really tell where this police unit begins and where it ends. This is a high quality, high resolution photograph. That's that unit when it's not even under that tree. That's the unit in the middle of the parking lot. And you see, that's the alleyway. That's the alleyway where it exits. Okay, and I want to be clear before I discuss this. This is not about whether you believe Officer Hymas or Officer Cunha. Nobody in this courtroom is going to call them liars. I have no reason to believe that they're anything other than good people. I have no reason to believe otherwise. But human perceptions can be wrong. They're humans just like everybody else. Officer Hymas said it was a Honda Pilot. Why? Because all I saw was the big H. We know it wasn't. Perceptions can be wrong. I'm not saying he's lying. He just misperceived it. He also said the distance was 30 to 40 feet. You've watched where Detective Tudor agreed those shots came from. That is much further back by magnitudes of 30 to 40 feet. And he was sure when he testified, no, we were in the middle of the road until he saw those exhibits. They were on the side. I wasn't parked under that tree. And then once again, when you see it, it is under that tree. And then as soon as I started engaging the vehicle, it had already passed me. And the state brought you the video where you can see the muzzle flash where he fires even just a little bit before it gets level with it. Once again, this is not to say that he came in here and lied. I would completely disagree with the state's counsel that this is about whether you believe Tyler or whether you believe these officers. This is a case about possible misperception combined with those other factors that I told you. A misperception is not a lie. I don't think anybody came in here and lied to try to have Tyler arrested. And as Mr. Salazar stated, think about that call before they arrived. They already have a white SUV in their mind. And so as soon as they see a white SUV, they're on high alert. Okay, there was already a white SUV. They were literally writing our report for right now. There was a carjacking with a deadly weapon. And they testified, they're immediately analyzing that as a threat. Immediately seeing, okay, is this guy going to be a threat? And then what happens is, as soon as they hear a gunshot, I'm under attack. That's what he testified to. I'm under attack, and I have to lay down suppressive fire. So the brain is processing something very intense, very stressful in just a matter of seconds, and it's creating a narrative that makes sense. I wouldn't expect, him to put all the pieces together. That was for the detective to do. You don't have seconds. You have hours. You can take a look at all this. You have the luxury to have all the facts, all the evidence that those officers didn't have in those few seconds. And you heard about Tyler's history of careless but not malicious firearm behavior. The act that he described is not out of character for him. He'd done similar things in the past. The accident inside his room, where he tried to dry fire it and a bullet came out. He hung out with friends who had a similar blasé attitude with firearm safety. And this was one of my regrets, is that I didn't mention this to you in opening statement. I wanted to so that you'd be prepared for it, to know that Tyler lied. I was kicking myself that I didn't tell you guys about it because I wanted you to be prepared for it. This was just another bad decision in a string of horrible decisions. if he's somebody that's dumb and careless enough to shoot out of his window, he's also somebody that's like, we're not talking about sophisticated people in this case when you're talking about like the lay witnesses here. This is somebody who would also just think, oh my gosh, like they think I'm a suspect. What I need to do is just distance myself from this as much as possible. And he thinks that's a good idea. But this was an incomplete police investigation. It wasn't an investigation, it was a manhunt. Who was that person? They never did what we did. They never went to the scene and tried to see where could these shots could have come from. They just all they were focused on.
3 minutes,
I'm sorry, Judge?
3 minutes.
And so I want you to think about this, like if you're a homeowner and this is your yard, it's your responsibility. You have to cut the grass, you have to pull the weeds, you have to do all that. And then if you don't do anything in 3 years, and then we come in as a neighbor and cleaned up, you don't get to complain that we didn't cut the branches the way you wanted them to be done. It was never our job. It was their job from the beginning. The burden is always on the state. Never does it shift to the defense. And so they never did any of this. They never tried to recreate it, measure it, look at what it would have looked like. And I want you to think about why. And it's almost understandable. Once that train is in motion of an officer involved shooting, you almost have an incentive to not question, to not be the officer that says, hey, could it have maybe have been something else? Could you imagine? That's a dangerous job. You have to know that your brothers and sisters have your back. You have to have their trust. You have to know that they're going to be there for you and they're going to support you. If you have somebody that's always questioning you, then you're not going to trust them. And so he has an incentive to not really go out and try to do the work that we actually did and to determine, you know, what would this have looked like from the different angles? What would that have done to Detective Tudor's career if he's the guy that says, well, maybe you guys misperceived this. Maybe it wasn't what it looked like. He'd be a stranger in his own department. I don't think he'd have a lot of friends, and that would be a career killer. And once again, that was not our job. That wasn't our burden. Okay. I know that there's going to be a lot of pressure to support the police in this case. That was my greatest fear for this case. But your oath is to decide the case on the facts and the law. There's nothing in that jury charge that's going to say what message you want to send. You don't worry about messages. That's not what you're deciding. You're not deciding who do I like better, anything like that. And the criminal justice system, when we're dealing with years of life as the currency, you can't get it wrong. You just have to have one doubt that's reasonable. And I know I'm kind of running out of time, so I want to, obviously you saw Tyler's Facebook post. He supported police when he had nothing to gain, when it was an unpopular time to do so. And there was no evidence at all that he had any animosity for police officers. The timeline supports his innocence. He left the bar at about 1:55 a.m. and Sergeant Lloyd confirmed that. And it confirms what he told you. I'm not asking, and okay. The state's theory rests on contradictions. So despite drinking, having bad eyesight, and it being in the darkness, he immediately spots officers up a hill in the dark with lights out, when his first chance to spot them would have been while he's driving
10
on the streets.
seconds.
I'm sorry, Judge?
10
10
seconds.
seconds. And so despite that tremendous, vision, he takes 3 terrible shots that have no chance to hit that vehicle, and he doesn't shoot the shot, if that was his objective, where he actually could have hit them.
Time.
Can I do one closing remark, Judge?
1 sentence.
Okay. And so this is done during not where he's out roaming about. That's not what any of their location data suggests. So how can he do this act that's so heinous when he's also doing an act which is so mundane and so routine, taking his dad's vehicle back? None of their case makes sense. Tyler, you have plenty of reasonable doubt. We're asking you to find Tyler not guilty on every charge. The same logic applies to counts 1 through 3, that he didn't see them, he wasn't shooting at them, wasn't shooting at a car, wasn't shooting at any people, didn't know they were there. Thank you.
All right. State, I'm going to add an extra 30 seconds. You have 10 minutes and 30 seconds.
Shootout tonight, please fuck. Those are the words that defendant sitting over there texted to his baby mama 30 minutes before he went on a hunt driving around, located this police vehicle, and decided to fire at that vehicle. He saw that vehicle, and that's evidenced in Defendant's Exhibit 139. When you retire to the jury room, look at this. Look at how you can see that entirely black vehicle with no flashing lights on the top, the mount for the lights, no decals. You can see it. He saw it, and he had the perfect opportunity to execute what he's telling Tatiana, that he wanted to be in a shootout. He wanted to engage in gunfire with somebody, and he did. Now, Mr. Garaham already went over the law with you, but I'm going to talk to you about the mental state. Intentional, the defendant's desire. The defendant testified that it was his desire that night to fire that 9mm, because he wasn't going to have his dad's car and he wasn't going to be able to go to the gun range. And so he gets this bright idea that he was thinking about for more than 30 minutes to go and fire and pop them off in that church parking lot. Okay. The text messages support the intentional. I've just gone over that. And the carport video. That first muzzle flash is going to tell you everything you need to know about this case. It's not that hard, okay? The defendant testified that he holds the wheel from under. It's not that hard to go like this, okay? The sound of the engine revving. You all see that on the state's exhibit. All of those are intentional acts that go to his mental state on that day. You heard the testimony of Officer Jaimes, and we'll go over that, and then the location of the shell casings as well. Knowing. Ladies and gentlemen, that parking lot, you all saw all the light poles in there. You saw the lights on the side of the building by exactly where the officers were parked. He knowingly engaged in these acts, and he knew that that police vehicle was there. He testified that when he would have taken that left turn into the church parking lot, he had a view of the entire parking lot. That is supported by their own exhibits that they entered yesterday. When you retire to the jury room, go look at that and compare it to the evidence that the state presented. And reckless. The defendant admitted while he was on cross-examination that even if things were how he's now concocted, he perceived them to be at the time, he disregarded several risks, even if he was on Santa Gertrudis Street. Testimony is evidence, so we're going to go through the evidence really quick. Sergeant Pearson testified. He processed the scene. He collected those shell casings, and he testified to the lighting conditions. And in that CSI video, you can see those multiple light poles and lights illuminating off of the church side building. Officer Urbanowski makes a scene on Buckmore, where he observed the Nissan Rogue, and he observed Tyler's name tag and those shell casings in the front driver's side of the Nissan Rogue. Joseph Gonzalez testifies that the defendant's father, that he woke up to heavy police presence at his home that morning of May 22nd, 2022, and he let the police know that the defendant is the only person that had his Nissan Rogue. Detective Robles then conducts the surveillance. He locates the defendant at that Oak Valley apartment complex here in Bear County, where the firearm that matches the shell casings that were located on scene was. And he takes the defendant into custody and transports him downtown. So you heard the testimony from Officer Acuna, and bless his heart, he was only 2 months on the department. And his commitment to our community is so strong that after he was fired upon, he's decided to stay with the department. He testified that he saw the muzzle flash and immediately ducked. What does that tell you? That he observed the muzzle flashing in his direction. Okay, why else would anybody do that? But to threaten the person and place them in fear of imminent bodily injury. We all know what happens if a bullet hits you. Okay, and Officer Jaimes testified that he was expecting to take one to the dome that night. That testimony cannot be disregarded. Also, guess who else has vision issues? Officer Acuna, but he has the wherewithal to say, hey, I am not going to add any more danger to this situation. I am not going to fire my weapon. Something that defendant should have done that night. Officer Jaimes and Officers Acuna's perception is one that you can trust because they were sober, they were on duty, they were doing their job and protecting our community. And their versions are corroborated by the video evidence and all of the other evidence that we have presented to you all in this case. Now, how can you tell if somebody is a police officer? We talked about this in jury selection. The badge, the car, the marked patrol car, the decals that are reflective, okay? And then they want to talk about astigmatism. You heard their witness testify that for your astigmatism to be activated, the light has to flash in your eye, okay? Look at the state's exhibit and what that would look like to an eye. Now, Harold, this is very important. The defendant and Harold did not have an opportunity to corroborate their stories before they went down to headquarters. They've since had 3 years to do so. And so what is important? Harold never tells Detective Martinez about Two Rivers Tavern. He never says that he was following the defendant down O'Connor Road. But what he does say is that he was blindsided by this entire event and that he didn't believe Tyler at the time. Tatiana testified that the defendant asked her to lie about his whereabouts during the time of this offense. All of that goes to his mental state at the time. He knows what he did. And now you do too. Then he gives his interview to Detective Tudor. He lies, and more lies. He says he went to the bar before dropping off the car. He was never shot at all. He dropped the vehicle off and it was fine. There was no damage to the vehicle. He's never even shot this 9mm. He has no clue about shell casings or why they would be in the vehicle.
3 minutes.
And the ballistics will show that he's innocent. Okay, and he says something very interesting because he's trying to sell his story. Let me tell you something about honesty. You can't get caught for it. Well, newsflash, you did. He did. He got caught for being dishonest. And that was his story. And he was sticking to it. And then here comes all the scientific evidence. The DNA that Robert Saylors testified to, the GSR, by the way, the shirt that he's wearing in that police interview came back with 10 of 10 particles, okay? And then the one on the right, which indicates that he was firing and he's admitted to. And then Holly Warden, that the shell casings do match up. And so then come the text messages. Shootout tonight, please fuck. I'm going to jail. Bro, got into some shit. Be up at the store. And regarding the shootout tonight, he sure has an explanation for that now. Oh, he was trying to manipulate Tatiana. But then when I confront him about it, Tatiana was the one that was trying to get in contact with him. It was not the other way around that night. And then when he's talking to Detective Tudor about that, he goes, oh, it's because I heard a shooting. Nothing that came out of that defendant's mouth can you believe, okay? Because it's all lies. And then after viewing all of this evidence, he concocts this story, okay? He's transforming it because nobody's gonna believe that I didn't fire the weapon when I have GSR on me, when the shell casings match my gun. Nobody's gonna believe that. So then I'm just gonna change it, okay, to something that can maybe be believable, despite overwhelming evidence that the state is bringing you. You are the exclusive judges of the credibility of the witnesses. And he has the biggest incentive to get up there and tell you a story that's not based in fact, reason, or supported by the evidence, okay? He wants you to believe he's telling the truth now after 3 years. He remembers only the facts that are beneficial to his defense. I can't remember if I was wearing my eyeglasses. Oh, but I know I didn't see that car. And I know that I didn't know that they were police officers. All things that are in the indictment that he is seeking to escape. His rendition is not supported by the evidence at all.
20 seconds.
It's easy to Monday morning quarterback when you know that you are going to face a jury of your peers. I want you to imagine what our community would be like. what our community would be like if this is how police officers are repaid. When they're finishing up a report for an aggravated robbery, and this defendant gets to walk scot-free.
Objection, improper
Five.
argument.
It's a plea to law enforcement.
I think it's an improper plea to law enforcement. Objection,
All right,
improper.
that'll be overruled. All right,
Is that the community that you want to live in?
time.
Find him guilty.
All right, ladies and gentlemen, Deputy Laura will take you to the back to select your foreperson and begin your deliberations. Everyone, please rise for the jurors. All right, everyone, please be seated. And everyone, please confirm.
You want to stop?
Yeah.
You didn't answer about it.
Thanks.
And he's busy.
Right.
Oh, yeah.
Mr. Gorilla. Yeah. Okay. Well,
Checking in?
Yeah, she was on, multiple times, wanted a complaint. I have the, wanna see the. I just need that back. Good morning. I have,
I have. It's always a tongue twister.
Chili.
Such like that.
I was about to say, he's done this. It's like the last 3 days has been like that.
48 all day.
yes.
Yeah.
We were trying to think that never happened.
Yeah, darn it. Ain't a bad thing.
At one point it was so loud. Everyone was sharing the words.
Let me just.
It used to have cardboard boxes.
Okay, this is my notes.
Like a plywood, it was like that was. And that's where they were, they were trying.
I have one under Gonzalez for 66. I have 66 withdrawn.
Yes, everything in there is counselor.
I'm sorry, I have 65 withdrawn. Then I have a 66. I think the foundation was laid under Gonzalez. But then now I'm going from Gonzalez to see if 66 was admitted anywhere else. So just give me a moment. Okay, what I can tell you is the next exhibit, just 1 second. You are dressed appropriately, right?
Yes, ma'am.
But the words antisocial social club, that's probably not the best thing to wear for court. All right? All right. But I would always tell my clients, I understand that everybody doesn't have a suit or tie. So that's fine. I would always tell my clients, if you don't have a suit or tie, just wear some jeans, not the ripped, club jeans. And a shirt, and you're good. You don't need a tie, you don't need a jacket, you don't need all of that. Just keep it simple. But I will tell you, your attorney will tell you, don't come with things on your shirt. Like, for example, if you're charged with DWI, the worst thing would be for you to come with a T-shirt with drinks on it. Or if you have a marijuana charge, to come in with a T-shirt with a marijuana leaf. So just a clean T-shirt, okay? All right. Once you sign the reset form, you're excused, all right? You will. Oh, yeah, you got to remember though, okay? I don't take it or hold it against people, but if you were going to a jury trial, sometimes jurors may look at that some kind of way. All right. Right, so just stand there and she'll give you a reset form. All right, let me. Yeah. Okay.
Yeah, that's it.
All right, you're welcome. Have a good day, okay? Be careful out there.
I'm sorry.
Down 23 is.
I'll just let her know the witness if it's on the wall.
Who's here on Lorianne Valdez?
Oh,
here it is. Sorry. Good morning. It was on the back side. I had it like this. Okay. Do we know if?
I don't know, probably the very kind of ABC. Friend of mine. Yeah.
So, I mean, would you accept or has it been rejected for not? Right, so this is, and she doesn't, Vashon, she doesn't have a warrant. This was just an alternate minute for felony drug court.
Today was a compliance hearing because she failed to appear for those screenings.
All right, so counsel, what's going to end up happening? I usually have client compliance hearings to see if we can do some behavior correction and get them in compliance, but she's not even here. Deputy Laura, could you make an announcement in the hallway for Lori Ann Valdez? Yes, and then what's going to end up happening is a motion to revoke will be filed if she's not here. Hi.
How are you?
All right, how's the Capitol going? It happens.
Or starting again Monday.
Oh, yeah, that's what they tell me.
No fun.
No. So do you have a case in here?
I do. Do you have a minute? Or-
Sure, just, you have to have them fill the file.
Yeah.
Yeah.
Judge, I've texted her. If I hear from her today, can I get her in here?
Right. Yes, but a motion to revoke is going to be filed now. All right, thank you.
Thank you, Judge.
Thanks, Judge.
Oh, Vashon, do you need this back?
Yes.
Thank you.
You're welcome.
Thank you.
Thank you, Deputy Laura. I completely forgot about that.
Sorry.
How are you? You doing okay?
Oh, yeah. I mean, life.
Dealing with the VA.
Are you doing the Veterans Club?
No, I'm talking about the VA with my brother.
Oh,
It's just, oh my gosh. People think,
yeah, it's not easy, and now with these cuts, it's worse. They
Yeah.
cut thousands of employees from the VA, and now it's gotten worse.
well, you know what gets me?
Hmm.
This is always one of my pet peeves. You want people to serve the country, they go off into battle. To me, services for veterans should be top notch. The VA is not top notch. You should be able, that should be a one-stop shop where you go here, you go here. It shouldn't be, oh, it's taken me 4 months to get this appointment, so I can't miss it because it takes 4 months. I mean, it's nonsense.
And then you get there and you gotta make another appointment for some other place 4 months later.
Yes.
It's a mess.
All right, let me just, I have to put this in the system.
Joe.
Okay, so that's not including. Understood.
Next case has VA implications as well.
Well, I tried my best to get things moving,
No, I know.
but in the VA, I know people are not paid what they should be paid or whatever is going on over there, but veterans are just not treated appropriately, and I don't appreciate that. Yes, he does. All right, Mario Hernandez,
Yeah. So
we've got a violation report.
you want to talk to me?
Oh,
All right.
probably need to confer with the state on the violation report because we have a confirmed tamper.
Diabetes,
If you talk to the state, they'll, yeah, so confer with the state.
because he's got all his meds and
Right, just confer with the state, then approach, it would be somebody from over here.
he does rub it because his leg diabetes.
Oh.
He's not-
Okay.
And he's my buddy for 3 years.
Okay.
Promise you, he's almost like.
Jose Martinez Cardenas. Jose Martinez Cardenas. Vanessa Lynn Marivete. And for the attorneys, Sherry Dye is by Zoom on Cheeseman, I believe, and it's a motion for travel. All right.
Oh, sorry.
She entered a plea and this was for evaluation, is that correct?
Judge, this is actually a compliance hearing for an outcome for felony drug court.
I don't know, I just have a blank sheet of paper. Let me see.
Here you go.
Thank you.
That's the outcome. Sorry, Judge.
Sure, no problem. All right. So she has already entered a plea. And she was rejected from felony drug court. All right, so they're saying that you don't have stable housing. What's going on with you?
So I stay right now where I can stay. I recently just got a phone because I had to get a brand new phone. My ex has all my belongings and I personally don't want to he lives on the property where I'm not supposed to be. And so I don't want to have contact with him or go to the property or send anybody there to get my belongings. So I've been trying to figure that out. I did speak to my probation officer and he said that he would try to work with me to see how I can
Just
get
one
my
moment.
belongings.
Could I get the steps on this case? It's Vanessa Lynn Merivet. See, we have Odyssey now, so everything is supposed to be electronic, but they don't have the manpower to put everything in the system, so. So none of your information is in the system. So is there a reason, because I see here that they were trying to contact you through your parents?
Yes, so as soon as I got a phone, I was made aware of, that through my mom and stuff that,
I'm talking to Mike because probation cannot hear you, right?
so I was made aware that that they wanted me to show up and stuff.
Mhm.
So I was trying to figure that out too, and I had talked to my probation officer, but he told me that he wanted me to pull this application in the court first.
So who are you living with? Where are you staying?
So right now, I have been like, just pretty much staying in hotels and things like that, but because I don't have access to like my IT or social security card.
So how are you affording hotels?
So it's getting paid, through my dad right now, because, I do have job offers, things like that, but the thing is, I don't have access to my IT or social security card.
So why are you not staying with your dad?
Because, he lives in Wisconsin right now.
All right, so why are you not staying with your mom?
They, all my family stays in Wisconsin. The closest family members that I do
Oh,
have is in Boston. But, I don't want to like do anything else. So,
All right, just a second. So here's the thing about Odyssey. If Odyssey is not going to have the stipulations on file and paperwork is missing, I don't even know why we have Odyssey. Like, I have nothing to go on with regards to this case. I know there's no contact orders in place with you.
I'll print out the judgment.
No, I just need the stipulations. I don't need it.
Stipulations, and into this. Looking at me.
Does anybody have a police report?
Judge Adamson, I'll do right now.
All right, thank you. If you could just email it to me.
Okay.
And counsel, what's being emailed to me is what would have been what was in the stipulations.
Judge, I
Yes.
give you another update while you're waiting
Yes.
on that. Miss Mirabente was supposed to have the TAP evaluation conducted while she was in custody. And if she was not accepted into felony drug court to follow the recommendations of the TAP, she was released without having a TAP, so we did not get to the TAP.
All right, let's do this. If you're drug tested today and you're gonna get drug tested today, what are the results going to be?
have nothing.
All right. So let's get our drug tested today.
Okay, and I just wanted the court to be aware that we did complete the mental health evaluation and she was all clear there.
All right, so you're gonna do a drug test today. And then we're gonna come back and counsel, then at that time, the court will make a ruling on this and what should be done. And then hopefully by then, we will have something on your case. Okay? So if you'll talk to Miss Abrams is gonna tell you where you need to go for your drug test, okay? And then after you've completed your drug test, you're gonna come back here and that drug test, you're not gonna be charged for it, okay? All right, thank you.
When do you want us to come back, Judge?
As soon as she finishes her drug test, it's the location where she's getting the drug test, it's near the Bear County Jail. And then she'll come back and we will have the results
Today or tomorrow?
today.
See you tomorrow.
Jose Martinez Cardenas, are you here? All right, they're not. This is coming back for the afternoon.
Yes,
And could I have the following Cheeseman, please? Mhm. Yes, but where is he?
No, I'm just saying,
Yes, thank you. Kylie Brooks. Who's the attorney? Okay. Thank you.
Judge, you have the supplemental report as well as, of course, some of them right there.
Everyone, whisper. Yes.
We're coming before the court to ask for permission for Mr. Brooks to have permission to go to Spokane, Washington to live. Currently he is unhoused and he only has his father here who doesn't really necessarily want him to live with him. In Washington, he has stable living plans to live with his mother. He has a job waiting for him. He has already been accepted, from my understanding, to Spokane, Washington, through the ITOT system. The state has no objection to him going.
Okay. All right. So this is what will end up happening. You'll be transferred to Spokane, Washington, but that officer will give the court updates. And if you violate your conditions of probation there, what will end up happening, they'll ask for you to come back here because a motion will be filed. They'll let us know. And you'll have to come back here to answer for those charges. Do you understand? All right. You're welcome. Do you have any questions?
No, just thank you.
Oh, you're welcome.
Thank you for your.
Oh, you're welcome. I do my best. I try.
But you
All right. Good luck to you. If you ever need anything, please let us know. Okay. All right. Thank you.
Judge, may I approach?
Just give me one moment. Let me put this in the system. Just give me one moment, counsel.
Concerns for.
You know, we have to put everything in the system now and it doesn't, even though we put it in the system, half the time it doesn't show up. All right. So counsel,
May my client have permission to be excused from the courthouse so that he can go to get money orders in order for us to do a plea today? He has to.
Yes.
Have him exposed. Thank you, Judge.
Yes.
And we plea when we return.
all right, thank you. And one of Monica's client hasn't shown up. It's Cardenas. Yes. All right, counsel.
You know, my client has no transportation and doubts that she can get any this morning.
Well,
Therefore,
is she here at court?
from her father, I suspect, but now she would have to walk to the jail and come take a piss test, come
No, do
back walking.
I'll have somebody come over here and do a UA.
All right, thank you.
All right, thank you.
I can say everything.
I'm just tired. Already passed away. Pretty care. August 4th, 3 months ago. No, I. Oh,
Yeah,
about 68.
I'm gonna see if I can get somebody to come over.
Actually, it's very.
Morning, Your Honor.
Sometimes they're bored, she's working.
They were right in that assessment, but things were addressed, and I believe defense has brought things and will bring things to the court attention.
Thank you.
Yes, what do you want to bring to my attention?
Judge, you have.
America, the land of medications.
From the VA, Judge.
Well, everybody needs to get a second opinion.
Yeah, my client, Mario Hernandez, Judge, dear friend of mine for many years, doing this pro se, or I'm in pro bono rather. Mario is a US veteran, some combat, going through the VA for many things. Unfortunately.
Well, make sure you get a second opinion.
We'll deal with all the allegations of this case down the road, Judge. Unfortunately, there was an accident which caused.
No, I'm telling you, I am serious. I know sometimes that when you go to the VA, people are just accepting, but you should always get a second opinion. And I don't know why with the VA, it's as though you can't get a second opinion because you have to stay in that system. So just make sure you get a second opinion. Write your legislature, write your congressman to say, hey, I would like to get a second opinion because that's a lot of medications.
I think, why don't we just let him address the ankle monitor piece? I'm okay with him addressing it, Judge.
What is going on with the ankle monitor?
My foot, it gets swelled up. And then I can't really function.
As well as because of the diabetes?
Yes, and I'm diabetic, I have high blood pressure, sleep apnea, I mean, it's been real bad.
All right, and so let me ask you this, and this is just for me to understand.
Yes, ma'am.
So the VA will give you medication, right?
Yes,
And
ma'am.
then you'll have some sort of bad reaction to that medication, and then they'll give you some medication to take care of that. And then something else will happen with that, and then they'll give you more medication.
Yes, Your Honor.
But no, I'm very serious. Make sure that you get a second opinion.
I have been trying, Your Honor, and last time I talked to this, one of the pretrial officers about removing the.
No, I mean,
One
the
of the
second-
just to fucking get MRI, my shoulders, and they couldn't do it. It's been.
Guess
I've been
what?
Dealing with this for 10 months.
Here's the thing about that. There's a legislator right here. He's your attorney. Say, hey, I want a second opinion. I need to get my shoulder. I still don't understand why, when people are trying to get appointments with the VA, it's months.
Yes.
And you're supposed to be in the military. You know, everybody wants to wave the flags. We love our military, but then it's not shown. So your legislator is here.
I need a promotion, Judge, to the United States Congress.
Yeah, you can talk to him and say, hey, I want to get a second opinion. All right, I understand your issues that are going on, and I understand that when you have diabetes, that will skew any tests that you have for the alcohol. So I understand. With regards to the monitor, you have to be monitored some sort of way.
Yes, Your Honor, but like I said, I haven't had a drop of alcohol since the accident. I mean, since then, I haven't touched anything. I'm not doing anything wrong.
No, I
I'm trying
understand.
to work, and I didn't work.
Here's the thing, I understand what you're saying, but legally, the law says, and he will tell you, the law says you must be monitored by some sort of alcohol device. So what you need to do is speak with your pretrial services officer, and I will send them an email also if there's no objection, and let them know what all of your issues are, and let them know if there is some other device that they can recommend for you. And if there is another device, I think now they may have started the wristwatch or something, or the blow. So talk to your pretrial services officer, see if they have something that's in your price range. And then your attorney can speak with the state and see if they have any objections to it. If the state has no objection to it and you're being monitored, I have no problem signing it, okay?
Thank you, Judge. And Judge, just to be clear, the reason he was on the ankle monitor for some time, he wasn't driving at all because of the injuries that had occurred during that accident. So possibly we'll talk to pretrial, as you suggested,
Yeah.
see if we could get placed on it and ignition and all of it.
Yes,
Because he's not that, I know him
Yeah.
very well.
yes. So if you contact them and I'll take that matter up. And you all are about to go in session again?
Monday, yeah.
Yes. All right. And how long do you think this session will last? You have any idea?
They're 30-day sessions, Judge, but unfortunately our illustrious governor has added redistricting, so if things don't go well, he'll call it again and again and again like they did last time.
All right. So Ms. Ferguson, what I'll do, I'll set this in 35 days approximately, and then we'll see where we are.
Yes, Judge. And if I need to file this, I wanted to come in. I didn't want to file the legislative continuance right now because I didn't really need it when it was dark.
All right.
I'm allowed to, but I didn't want to do that. I wanted to come in and address this with Mr. Hernandez. And to come see you, 'cause it's been.
It's always good seeing you. All right, so we're gonna bring you back on August 21st. Once you sign the reset form, you're excused, okay?
Okay.
Thank you.
All right, thank you. And again, second opinions, it should be standard for you're allowed to get a second opinion and even get a second opinion outside the system. But the only way you can do that, I've discovered, is you should write your legislature, email your congressman or whoever that is, and tell them, hey, tell them, hey, I want to get a second opinion and my appointment needs to be now. It can't be 4 months, 5 months in the future.
That's correct. Yeah, because I was in the emergency room last month for my shoulders. And I don't have an appointment with the primary until September 20th.
Because my thing is either we love our troops or we don't. It's nice for TV to say you love your troops, and what are you doing? All right, sir, once you just have a seat, thank you for dressing appropriately for court. They're going to give your attorney the reset form. Once you sign the reset form, you're excused.
Thank you.
And I will send that email to pretrial services.
Thank you.
All right,
Appreciate it.
thank
And
you.
excuse me.
Yes. Sherry Dye. And Tiana Chessman.
Yes, Your Honor.
All right, this is this family violence? All right, so there's a motion to travel. Is this correct?
Yes, Your Honor.
Are you ready to proceed?
We're ready.
All right, the court is calling night mag number 756623, State versus Tiana Cheeseman. Can I have parties announced for the record for the state,
Rick Daniel for the state of Texas.
for the defense?
Sherry Dye on behalf of Tiana Cheeseman. I'm present. She's present. We're ready.
Are you Ms. Cheeseman?
Yes, I am Mrs. Cheeseman.
All right. So it's a court's understanding defense that you would like for her to be able to travel. Is that correct?
That's correct, Your Honor.
And this case has not been indicted. Is that correct?
That's correct.
And how long has this case been pending, state?
Fine.
Do you have an offense date?
Yes, I'm trying to. It looks like it's been pending for a little over a year, March 20th, 2024.
All right, this has been pending since March 2024, over a year. So state, do you have any objections to her traveling?
At this time, yes, given the nature of the charge, the facts that are involved with the charge, the injuries that the child sustained from this defendant. And unfortunately, given the fact that at this time we can't confirm for sure the whereabouts of the child, we would object to this.
All right, and state, I know you're not in charge of indictments or tendering cases to the grand jury for indictment, but this hasn't been tendered to the grand jury in over a year?
That's correct.
All right. So Ms. Cheeseman, can you raise your right hand for me, please?
Yes,
Please let me swear affirm the testimony you give will be the truth and nothing but the truth, so help you God.
yes,
You can lower your hand, state your name for the record.
Tiana Cheeseman.
All right, Ms. Cheeseman, the complainant in this case is a child.
It is, yes, sir.
Have you had contact with the child?
Yes,
All right, has the child been placed back with you?
yes, with supervision.
And is that supervision through Child Protective Services?
No, everything with Child Protective Services was closed out as of October of 2024.
Oh, okay. So we were here on August 1st, 2024. The case still had not been indicted. And there was an agreement that the defendant was to have no unsupervised contact with minor children. And she has not violated that. She's still having supervised contact. So state, do you have any proof or evidence that she's having unsupervised contact?
Not at the moment, Your Honor.
All right, so where would you like to travel?
So I was supposed to be traveling to New Orleans, but that trip has now expired. Next will either be Dallas, Fort Worth, Texas, and Houston.
All right, and what would be the travel permit? What is the purpose of the travel?
Medical conferences, because I'm a nurse.
All right. Anything else from either side?
Yes, Your Honor. I would just like to offer to the court. I did provide Prosecutor Ashley, I apologize, her last name is escaping me. I did provide her with a certificate of completion of my client's parenting class and a closure letter from the CPS caseworker
I personally, as an officer of the court, will represent, I spoke with the caseworker. She had no concerns about Ms. Cheeseman, and stated that it was her understanding that her husband would be there. I'm not sure why the state is saying they can't confirm the whereabouts of the child. The home has remained the same for the child the entire time.
All right, this is what the court is going to do. The court will allow the defendant to travel for purposes of medical conferences or her employment. The court will note that the Child Protective Services case has been closed, and there's to be continued no unsupervised contact with minors. Is there anything else?
Your Honor, the court did grant my client the ability to perform the duties under her job when she sees children for work purposes. That was addressed previously in this court.
And the work purposes with regards to employment.
She's a nurse.
All right, but she's a nurse that she is supervised by other doctors, correct?
Yes, Your Honor.
Is that correct, Ms. Cheeseman?
Yes, yes, it is.
And the doctors are aware of this offense?
No.
All right. So she needs to be supervised by doctors, and they need to know the fact that she has this pending case because she's a nurse, and it should, according to licensing, this is something that should be told to her employer.
And Your Honor,
In state, this has been pending for a year.
I will
So-
have with intake today, as close to top list as they can to present.
All right, and counsel, you want to say something?
yes, Your Honor. Ms. Jackson was the previous prosecutor on this case and had not given those directives or instructions, and we were trying to work out something prior to her departure from the office. And so I made Ashley aware of that today so that hopefully we could work out some resolution in this matter.
Ashley Jones for the record, Your Honor.
Yes.
Just for the court clarification, at the last bond hearing on August 1st of 2024, I did go back and review that, and the court did allow the defendant to still continue to protect the children at her job. And so at this time, the state's not asking for any different orders other than that prior hearing.
Well, she needs to be supervised. And my understanding is that her employment, she's supervised by doctors.
Yes, sir.
All right. All right, is there anything else?
Nothing from the state.
Anything else, counsel?
Nothing further.
All right, thank you.
All right, thank you.
Thank you. Have a good day.
You too.
Thank you.
So it'll be.
Oh, thank you.
Yeah. Yeah. We are.
Hey, Judge.
Good morning.
It's something happened. We've been having trouble. Yeah. So, she's. Okay, and you, can you, well, she's, I'm not going back there, but, email her.
Ruben Apreciado. Hello.
Morning, Judge.
Good morning. Where's your client?
He is not here, Your Honor. He has another study county court as well, please.
All right. Deputy Laura, could you make an announcement in the hallway for Ruben Apreciado, please? Yes. I know I'm mispronouncing it. Court is calling 2025 CR 006431, State versus Ruben Apreciado. Could I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
Tiffany Seattle for the defense.
All right. This hearing was scheduled at 9 a.m. The defendant did not make an announcement at docket call. It is now 10:59 a.m. Counsel, have you had any contact with your client?
I've not been able to get him, Your Honor.
All right, Deputy, did you make an announcement in the hallway?
Yes, ma'am.
All right, State.
The state would kindly ask for a bond forfeiture and to issue a warrant, Your Honor.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Have a good one.
Maybe excuse?
Yes.
Oh, the lady? Yeah.
All right. Ruben Renteria. All right. Good morning. So what is happening with this case?
Your Honor, if you recall, this is a case where Mark LaPogas was a retained attorney on the gun charge. I believe his office had filed a motion for continuance. My client's also expressed to me that it looks like his office can be taking over the remainder of the cases. What hasn't happened right now. But we would like to get a little more time. It's my understanding that they're going to be in special session once again.
All right, I am recalling this for tomorrow. If they are not on his case by that point in time, we're going to proceed.
Okay.
On whatever case is remaining.
Okay.
All right, Ms. Ferguson, on Renteria, recall it for tomorrow. Oh, tomorrow's Friday, isn't it? Everybody's piping up. They're like, yeah, it's Friday. All right, recall this for Monday.
Yes.
All right, we'll have you back on Monday.
Thank you.
Thank you. Antonio Garcia. So we have an interpreter.
No. That's one. Oh, that, not the.
All right, so it's not the interpreter on this case. Okay.
Next one, Judge.
And which one is that?
I'll have the interpreter on Mr. Aguilar's case, Mr. Garcia's,
Hector Aguilar?
yes.
All right, then just step back. Let me do that because we have to get the interpreters out.
Aguilar?
You're welcome.
Yes.
All right, this is Hector Rene Aguilar.
It is, Judge.
This is family violence?
Yes, Your Honor.
Okay. All right, so this is final discovery. Where are we?
We've got all our discovery, Judge, and we have, we've got a plea bargain offer. We're not prepared to accept it right now, so we're asking for a plea deadline.
All right, sir, how old are you?
I'm 27 years old.
All right, Ms. Ferguson. Set this in 3 weeks for a plea deadline date. And I'll need an acknowledgement of discovery before you all leave today.
Yes, sir.
All right, so you're going to be back on August 7th. At that time, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date will be a jury trial. Do you have any questions about anything?
None.
All right, thank you. Thank you.
You're very welcome.
Do you need me to sign anything?
I do. I completed with the other case. Is that
All right, no problem.
Is that? Yes, no.
All right, Deputy Laura. Mr. Aguilar is complete. All right, so you may have a seat. I'm gonna tell him oh, you all were there? We're done. Okay.
Video?
And if you have your other client come back up, please. All right, Antonio. Hello. All right, so on this case, again, discovery, do you have it all?
Yes, Judge, we did.
Okay.
Or in the same circumstance.
Then we'll come back on August 7th for a plea deadline date. All right, state on Antonio Garcia, if you can do acknowledgement of discovery.
Yes, Judge.
Once you sign the reset form, let me find you on the docket first. All right, once you sign the reset form, you are excused. Thank you for dressing appropriately for court. Matthew Luis Martinez. All righty. Joseph Alamon.
We're here, Judge. Come on up.
Oh, and you know what, can you have them pull her file for me again? Let me see if I have it. Yes, I don't have it anymore, so if they could pull it again. Thank you. All right. And you're Joseph Alamon?
Yes, Judge, that's my client.
Okay. All right, so we're here for Discovery Council.
Yes, Judge, we're, the discovery, and there was another case that was hanging out, as regards to the second case, we don't think it's gonna get filed, so I'm not worried about it at this point. We did receive an offer today, and we have received discovery. I need to, go over with him what the offer would mean. It's a prison offer and everything, but, we should, be ready to go by next time, Judge.
All right, how old are you, sir?
21.
All right, Ms. Ferguson, recall this for 3 weeks for a plea deadline date, please.
Your Honor, I'm gonna be out of the country,
When?
but I'll get with her. So next week, we had a death in the family. I'm flying out Monday through
Right.
19 years old. He didn't wake up. I don't know about aerospace engineering at MIT. We don't know about that. Just.
Oh.
So, yeah, so that came up next week, and then Judge, the following week, I'm headed to Alaska for 2 weeks.
Okay,
But
so,
I'll be back around the 17th or 18th of August.
all right, Ms. Ferguson, can you put this for August 21st?
Perfect.
All right, your plea deadline date is gonna be August 21st.
We'll be ready by then, Judge.
All right.
I'm gonna talk to you at the this week, okay? And all that stuff. All right.
Go have some backup to the box.
Mark, take care of yourself.
Adam?
You know, Adam, yes, I'm sorry, Adam. Yeah, Adam, Mark.
I was
yeah.
like, I mean, he was healthy, a soccer player, and he talked to his mom, everything was fine, just went to sleep. And I mean, I don't know, they ruled out overdose, they ruled out suicide, they ruled out homicide, so the autopsy is gonna, I don't know.
Oh my gosh, I'm so sorry to hear about that.
We have affected parts in the family, sadly, and it's funny, thinking suspicion that's what happened.
Maravete? Hello. So I'm glad you tested clean. That's the first step, right? We gotta, so I want to make sure that you're clean and healthy. Now, the next thing we need to do is we need to try to get you stabled on housing and everything else. So have you been able to talk to someone about housing yet or no?
Yeah, I just have a friend of mine that said that, she could try to help me out with, a program or something, or, a job too, but the thing is, like, she, again, like, told me about the social security card and ID, so I'm just trying to figure out how I can get that, so that I can get started on a job.
Well, they do have a program. It's a nonprofit. It's called Build Better. I think Building Better. They may be able to help you as far as obtaining identification and getting license. Now, mind you, nobody's gonna walk you to a specific place, but at least they can cut down on the research you have to do on how to figure out to do it. You understand?
Judge,
Yes.
in addition, she can speak to her probation officer and we can get you
Yes.
with the reentry program.
All right, so this is what I'm going to do. Do you want to set it for another compliance to make sure that she stays on track and that she has the housing and everything taken care of?
Yes, Judge, and I'm gonna give her a reporting date, for her officer.
All right, when do you want to call this back?
Judge, can you give me 45 days? I want to see if we can get the TAP evaluation done within that 45 days as well.
All right, Ms. Ferguson, I need a,
Address the court.
yes.
Can we have their compliance hearing with her directly instead of in front of you? Because she didn't have a car. That's the big problem.
She can do it by Zoom.
Or
So that's how it works. But I can
Yeah,
tell you
you have-
this.
For now, I just have a cell phone, but.
All right, so here's the thing. If you're not doing well, you're gonna have to appear in court. I will work with you because I understand you have transportation issues. And this is for compliance, but it's to help you stay on track. You understand?
Yes, ma'am.
All right, I need a 45-day reset. All right, so it's gonna be September 8th. So you need to make sure that you're following through on everything. And if there's somebody you can't get in touch with, that's what I'm here for. Come back to the court, okay?
Yes.
All right, Ms. Abrams is gonna give you the information you need and who you need to contact to help you with everything, all right?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Anything that.
Matthew Luis Martinez. Is the attorney here? Sir, your attorney's not here. Just have a seat. Wilfredo Matei. Morning. Let me just pull you up here in Odyssey, which has not been a friend to anyone today. Oh my gosh. And then what was it? Tuesday, it went down. And there's no backup. At least it appears there was no backup because we couldn't find anything.
Hmm.
All right, so you're here for sentencing today.
Correct.
The court is calling 2025 CR 002-719 State versus Wilfredo Matei. How do you pronounce your last name?
Matei.
Matei. Oh, I did it correctly. Okay. Can I have parties announce?
Jason, you're here for the state, you're.
Brian Kimbrough for Mr. McKay.
All right, you entered a plea of no contest on May 22nd for evading arrest, detention with a vehicle. According to the plea bargaining agreement, the state will make no recommendation on your application. Punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. State is taking in consideration 2025 CR 003472 and 2025 PF 11391. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, Your Honor.
Any objection, state?
No.
Defense?
There is a correction, Your Honor, that I think will become more clear during the testimony of my client, but he does not, he is motivated for treatment and
I think there was a misunderstanding, and it says he wasn't, he was, and he is, so I'll let him explain.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Wilfredo Matei.
All right, you may proceed.
Your Honor, okay, just, in explanation, Mr. Matei has pretty serious record. He lived in Utah with his mother, who's present in court, and I was gonna call her as a witness also. And they moved here really to help, for many reasons, but one being to try to get Wilfredo into a better environment. But he has a serious drug problem. I can tell you that he has told me that he is serious about changing his life and has reflected on that while he's been incarcerated. And I know he wants to explain that to the court. He has attempted to get into drug treatment while he's been incarcerated. He was communicating with various programs to see if he could get treatment at this time, wasn't able to. So with that said, could you state your name?
Wilfredo Matei.
And Wilfredo, you have been in jail now for how long?
It's been 4 months this time.
And you have a pretty serious record in Utah, correct?
Yes.
Okay. And so you've been in prison
Yes, sir.
on a number of occasions.
Yes.
And have you reflected on your situation while you were in prison this time?
Yes.
And what did you decide?
I really want treatment, need treatment, and I've been trying to do doing programs and stuff so I can show that I'm trying to change and stuff. And I've written a couple of programs, lifetime recovery being one of them. And I've gotten approved, but just being incarcerated, I can't go to fifth until I get out. But thought a lot about that, and finally opening up to my kids to where I'm really at. Mom finally told me where I'm at, and it just made me want to show them that I can get out of here and do better.
Now, you've been diagnosed with some mental health issues, correct?
Yes, sir.
What mental health issues do you have?
PTSD, anxiety, depression, ADHD.
Have you been diagnosed with bipolar?
Bipolar also.
Are you getting any medication or treatment while you've been incarcerated?
Yes.
Okay. Has that helped you to sort of reflect on your life?
Yes, I take my medication every day. Don't miss that.
Do you think you could succeed on probation?
I think I can.
You think that
With help with program.
Excuse me?
With a program, yes. I need help. I need rehab. I really don't want to go back to prison.
Are you willing to do inpatient program as well as outpatient program?
That's the only thing I would want to do is inpatient.
The only thing you'd want to do is inpatient.
I would want to.
But you think you have a serious problem.
Yes, sir.
You believe that that problem has been part of the reason why you've gotten into these problems, legal problems.
Yes, sir.
Is there anything else you want to tell the judge?
Not trying to go into you guys.
Okay.
History of my me going to class, recovery and motion.
Okay. You're welcome.
Anything else you'd like to say?
I don't know. I don't really know what to say, but I don't want to say even just left my club defense prison. I know I have a history of going to prison and stuff, but I've never had a treatment program. I've never had a chance to get into a program or to a rehab or anything like that. And I went out of my way to write Lifetime Recovery and also New Direction Church, so I can go to a ministry. And they both proved me, but it's just being incarcerated, I can't go to the program until I'm released. But if I do get released, I plan on going directly there. Like I told my family, I don't want to make any stops. I want to go directly to Lifetime Recovery and start the process with them.
All right.
All right, I have one other witness I'd like to call.
Oh, just 1 second. State any fact questions or no?
No.
All right. I have a couple of questions for you. If there's no objection.
Yeah, okay.
All right, so I look at everybody as an individual. Sometimes people will come before me and their history is bad. Right? Honestly, anytime you get sent to prison, that's bad history. Your history is bad. It doesn't look good. So this is what I want you to explain to me. So in the stipulated evidence, you're saying that this motorcycle was sold to you. You have a key, okay. And then you evade, but then they say you have a bunch of keys on your person. And the police say that those keys are used to open mailbox. I think they said mailboxes. I think they said you are in possession of a set of jiggler keys. When asked, suspect stated that the set of keys belonged to a friend who is a locksmith, but did not know why he was in possession of a mailbox key. So you're riding on a motorcycle. Why do you have jiggler keys?
Because I took that motorcycle. Lied about that. I took the motorcycle. Jiggler keys were a friend's, but he let me use them because I was doing dumb stuff.
All right, and use the keys for what?
I have never used a key, but those jiggler keys, they were supposed to be to get into cars. But I never able to use them, like they're brand new keys.
All right. Okay, thank you.
Yes.
All right, you say you have another witness?
Yes, Your
Yes.
Honor. Maggie Vargas.
Mr. Matei? You're back against the counter.
Maggie Vargas.
Good morning. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Maggie Vargas.
You may proceed.
Thank you, Your Honor. Ms. Vargas, what is your relationship with Mr. Matei?
I'm his mother.
You're his mother? You gotta speak up, so.
I'm his mother.
And when did you first come to Texas?
They're gonna be 5 years in November.
And you came with Wilfredo?
With Wilfredo. He came after us. After he came released from prison.
Okay, and he's been living with you since then?
Yes, sir.
And why did you come to Texas?
I used to be a nurse at the University of Utah, Texas. I mean Utah. So we just wanna start over and take the kids out of Utah, you know. So we were looking for places. So I love Texas. So I said, let's go to Texas because I'm Puerto Rican. So and my family live in Puerto Rico and Miami. So it's like tropical.
Which some people don't know that Puerto Rico is a part of the United States, so thank you.
So I didn't want to stay in Utah because it's too cold and the winter is long. So we said, let's go to Texas. So we came right here random and just in a week we buy a house. And then we came like 2 months after that. So we said, I'm here. I've been 5 years.
Now, in terms of Wilfredo, do you believe that Wilfredo has a drug problem that is serious?
Yes, he.
You do. Did he have that problem in Utah?
Yes.
And has he ever had, your knowledge, has he ever had any treatment for that problem?
No.
Now, I don't know if you were able to hear, but Wilfredo was asking the court for an opportunity to get community supervision and get drug treatment. Do you think that he would benefit from drug treatment?
He will do better because he never had a treatment before.
And do you believe that if he got that treatment and if he got community supervision, he could succeed? Do you believe that?
I believe that. I will not give up on him. I will be here for him. I'm sorry.
And Wilfredo does have some mental health issues, correct?
Right.
He's been diagnosed with various things.
Bipolar, PTSD, depression, PTSD.
How old is he?
He's 29.
29.
2018. I
And
have
he
a lot
has,
of kids, so. I mean,
How many children do you have? How many children do you have?
4, but I have a lot of grandkids, so they're hanging out for the day for and all that. So. But we have like 4. We lost my father at the tragedy, so we lost his dad. He's been killed in Puerto Rico, and then my nephew, he just died 3 years ago by a drunk driver. And recently my grandson, he died from heart problems. So all that he's been, in all this situation, and he's been so depressed. I mean, I'm anxiety. I mean, I could not even breathe my own, or crying because thinking of him and just battle with the situation and all that. And I know one of the things that he's been going crazy and using drugs is because all these tragedies are coming.
Okay.
so Wilfredo was still a young man.
Yes, sir.
Do you believe that he has the potential to be a better person?
Yes, he's using, I don't know how to commit all this crime because he's sweet, he's singing so good, he played guitar, he was good in school. I don't know what's going on after, but he's not a bad person. He made the bad choices.
Okay.
Okay, thank you.
Any questions?
No question.
All right. So what types of drugs does he use? Do you know?
Amen. And heroin.
Do you know when he started?
I think when his friend in Utah being killed.
All right. Thank you so much for giving me insight into your son.
That's for his behaviors. I'm so sorry about that.
No, I mean, here's the thing. It sometimes parents think that children's behavior is a reflection of them. Now, if he's a 2-year-old or a toddler, that's a reflection on parenting. But at some point, it becomes our own choices, at a certain age. Okay.
I never use any drugs or nothing. I don't even drink. So I don't know why we learned that because we have a beautiful house and his house is no drugs at my house. Everybody's working. Everybody's a professional, I just want him to be changed.
All
Yeah, for his kids.
All right. Thank you so much.
Thank you.
You're welcome.
Thank you very much.
All right. Mr. Matei, you can come forward. Any other witnesses?
No other ones.
All right. State, do you want to continue with the offer that you have in place?
Yes.
All right. All right. So here's the thing. Your history does not look good. The state is offering you 10, and they are silent on your application. People always say that probation in this court is not easy. I mean, I guess it's not. I wouldn't know because I'm not the person doing the probation. But when I give people probation, it's designed hopefully for us not to see them again unless they're coming back to say, thank you for giving me a shot, right? So what I can tell you is I'm going to give you a choice, and I'm going to give you a choice because this is an evading arrest detention in a vehicle. I see your history, but these are the only 2 choices you have. Don't come back to me with a third choice. Don't try to do something different because you only have 2 choices. 1, I will send you to prison, and I will send you to prison for 5 years. You'll get credit for any time served. Or the second option is this will be a conviction on your record. I'm not going to grant him deferred adjudication, and I will sentence him to 10 years in the prison, suspended and probated for 10 years. Those are his only 2 choices. And if he chooses the second option, he's going to remain in custody because he's going inpatient treatment somewhere. So those are the only 2 choices. There's not a third choice. So do you need to speak to him?
A second.
All right. This is what the court is going to do. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. There's to be no residing with minors. There's to be 200 hours of community service restitution. How far did you go in school?
I graduated high school.
All right, there's 100 hours that will be deducted once he completes parenting classes. The remaining 100 hours will be deducted if he obtains a higher level of education or if he obtains some sort of trade school certification. There's to be field visits 1 time per month until further notice. There's to be an evaluation for DDRF. And there's to be referrals to SafeP. I'm sorry, an evaluation for SafeP. I think, just 1 second. Yes. There's gonna, just 1 moment. Strike the last evaluation for DDR. This is the order I want things. There's gonna be referral. And all of this is to take place in custody. There's to be a referral to felony drug court. If felony drug court doesn't accept him, then he is to go to SafeP. And Ms. Abrams, the referral to DDRF, how long is that taking?
Can't have multiple referrals going. The DDRF referral process could be month and a half. What I suggest possibly is let's do the funding referral and report it's not accepted.
All right,
DDRF, I mean, you already said safety, right?
yes. Taking consideration 2025 CR 003472, 2025 PF 11391. There's going to be 120 sober meetings in 120 days. And let me see something else with your history. And it goes without saying, you're a convicted felon. You're not allowed to possess any weapons. Do you understand?
Yes, I understand.
Probation, is there anything else? Is there anything else you need? I'm sorry, there's to be restitution, if any, to the complainant for the motorcycle.
Brett Castillo.
All right. I'm sorry, what's the name?
Brett Castillo.
All right, that will be Brett Castillo.
And Judge, in reference to also, there's another case that's currently open, a theft 1,500 to 30,000. If I can have a moment to speak with defense counsel, I'd like to try to maybe get that resolved because that'll obviously hold them up.
Okay. All right, let's do that. Did you review the probation? Is there anything else?
With the understanding if there is any open cases, felony drug court and or safety will not.
All right, they're going to take care of that, hopefully today.
Or soon, yeah.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we're off the record. Here's the thing. You're going to remain in custody until that other case is resolved. He cannot move anywhere. I'm not going to release him unless he's in some sort of treatment. And stop breaking your mom's heart. All right? All right, thank you.
Thank you, Your Honor.
You're welcome. Gregory Pernita. Good morning. How are you doing? All right, I don't know what's going on with what I'm receiving. Just a second. I have no idea. What is this case about?
Judge, you gave him 2 years supervision.
Yes.
However, his parole got revoked. So
All right.
we wanted a that probation period is over.
All right, do y'all have a motion to revoke on this?
No, Judge, so it's no motion to revoke or whatnot. I didn't have an opportunity to really understand what the parole outcome was, how long he was sentenced for, but my understanding, they were gonna ask for possibly a reconsideration of sentencing.
No motion's been filed. He did a 3-year stint
Mhm.
for on the 4200 charge. He paroled out after 17 months, picked up this charge and got probation.
All right, so here's the problem.
Now,
This sentence that I gave him was June 30th. Oh, we're still within the window. So what are you gonna be asking for?
Judge, I was just going to ask you. I've not seen this situation before.
What are you asking?
A reconsideration on his application for supervision. He's been in custody since the offense day.
Well, his minimum on this is 2 years. So you want to talk to the state and see if they have any objection, because once he's sentenced, there's no reconsideration.
Well, they had recommended the 2 year supervision. I'm sure they won't have a mind problem with 2 years to do.
I mean, you'll need to talk to them. Yeah. So once you talk to them, I'll take care of it. Okay. On Wilfredo Matei, what other case is this? I don't have the other file for it.
I have the number. He just got indicted after he took this plea. It comes out of the same fact pattern, part of the same deal. So, I wanted to bring him back either tomorrow or Monday to take care of that case.
We can do it Monday.
Okay? Okay.
Yes. All right, thank you. All right, Norma Matei, bring him back on Monday. Sure, just give me 1 second. Let me put this in the system. Yes. All right, Brian Adam Sanchez.
Judge, I conferred with with the state this morning and got an offer on Mr. Sanchez. I was hoping with some time so that I can do that with my client and maybe have him do a couple other things and see if I can't get it a little better, Judge.
All right, so you have all discovery?
I can sign off on that, Judge, yes.
All right, so state if you'll do the discovery acknowledgement.
Yes, Judge.
And Mr. Sanchez, why were you late for court?
Really looking for a partner.
All right, so here's the thing. You have to be on time for court.
Yes, ma'am.
I note that this is your first time appearing, so next time, be on time. Otherwise, what can end up happening is a warrant can be issued and you be placed in custody. You understand?
Yes, ma'am.
How old are you?
I'm 31.
All right, Ms. Ferguson, set this for 2 weeks for a plea deadline date, please. All right, we're going to come back on July 31st. At that time, you need to let me know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next setting will be a jury trial date. Do you understand?
Yes, ma'am.
All right, thank you for dressing appropriately for court. Just have a seat and Ms. Ferguson will give you a reset form, okay?
Okay, thank
All right, thank you.
Thank you, Judge.
You're welcome. All right, and are you all needed some guidance on something?
May I grab him from the hall real quick?
Yes. Yes.
Matthew, my feelings on the doctor.
That's
my first appearance.
All right, thank you. I've been calling, I think I,
run the children's court.
oh, sure, no problem. Just give me a moment and I'll call you, okay? Hello, counsel. Guidance?
I stepped out after I thought you called another case. I apologize.
Oh, no, I did. I had called another case, but we finished.
Mr. Pernada and the prosecutors, everybody agreed to instead of 2 years supervision, to a 2-year sentence on this new charge.
All right. So this is what I would have you all to do. If you will just print out the plea bargaining page sheet and just enter it into evidence as amended.
Sure.
And then we'll go on the record with it and then we'll sentence him and get another trial court certification.
Perfect. Thank you.
All right, thank you. Who is here on Jose? Yes.
So Judge, you don't want to file an NTR or anything to do it that way, everything?
Yes. Yes, because they're still within the 30 days. Jose Sanchez? All right.
Sanchez?
Is he here?
Yes, he's here.
Do I need to call another case before him?
He's coming, Judge.
Okay.
We're gonna get this done.
Okay. Mr. Cox. Hey. Court is calling 2020 CR 6566 and counsel, you're on this side. State of Texas versus Jose Rizzo Sanchez. Can I have parties announced?
Rick Payne for the state of Texas.
Adelie Silver for defense.
And are you Mr. Jose Rizzo Sanchez? Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Jose Rizzo Sanchez who was placed on deferred adjudication in 2020 CR 6566 for the offense of assault, family choking, strangulation on August 23rd, 2021 for a period of 2 years? Is that you?
Yes.
State?
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation condition number 2. On or about the 7th day of June, 2024, in Bexar County, Texas, the defendant, Jose Rizzo Sanchez, did then and there illegally use a controlled substance namely methamphetamines, in violation of condition number 2.
You said on the 7th of June?
Yes, Your Honor.
I don't have a motion to revoke with the 7th of June on it.
This is the first one at the top I read.
All right. I don't know why I keep getting the incorrect motions to enter adjudication of guilt. Okay. To that, how do you plea?
True. Waive the remaining violations, Your Honor.
No objection from defense, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a post agreement?
There is not, Your Honor. We're going to go open as far as our recommendations.
All right, state, what are you requesting?
We're requesting adjudicate the defendant and sentence him to 3 years TDC.
All right,
We're recommending to follow probation's recommendations.
and what is that
That
recommendation?
is a set.
All right, would you like to tell me anything, sir?
Hmm.
All right, I don't think you're a good candidate for probation. This is not your first MTR. You've had a previous MTR for the same offense. Do you understand?
Yes, Your Honor.
All right, the court is finding condition number 2 true. The court will find you guilty. The court will grant the motion.
May we talk about time, Your Honor?
Yes.
Your Honor, then in the alternative, we would like to ask for 2 years TDC. No new offenses have been picked up. He has completed status twice, aftercare once, outpatient once. And he currently has 231 days in Bexar County Jail, as well as the 2 completed status inpatient programs. Only 1 aftercare was completed.
Okay. All right. So it appears though that nothing is working with you because you're continuing to repeat the same violations.
Thank you, Your Honor.
All right. This is what the court is going to do. The court will find you guilty, grant the motion. There's an affirmative finding of family violence. There's to be no contact with Vanessa Sanchez. State, has there been any new offenses or violation of the no contact order?
Not to the state's knowledge, Your Honor.
Probation, has there been any violations of the no contact order?
Judge, on the motion to revoke, there is a violation of condition number 27. In that on the 12th day of July of 2024, there was contact or attempt to contact Vanessa Sanchez.
Your Honor, I
Or
would
a
like to,
family member by telephone, mail, or person. I know they waived that violation, but that is just an unruly.
Your Honor, so that was he admitted to probation that the CW was going around to his home. There are incident reports where him and his family, since it is a family home, did call because she is returning to the home because her children do live there.
All right, this is what the court will do. The court is going to, as previously stated, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with Vanessa Sanchez, no residing with children, 4 years in the prison. Did you review the document entitled, and I'm sorry, credit for any time served? And credit for any time served in inpatient treatment successfully completed?
The inpatient part, Your Honor, or the aftercare part?
Inpatient.
Okay.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain, I'm sorry, because this is not a plea bargain agreement, you do have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction in an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition, If you have a question about any of that, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, and then the court will recommend the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. However, it's there to help rehabilitate you. Do you understand?
Yes, Your Honor.
All right, good luck to you.
And he still has to ask for that when he's there as well.
Yes.
Correct? Okay.
Yes, thank
Yes,
you.
thank
Good
you.
seeing you.
Nice seeing you as well, Your Honor.
Norma, have you ordered anything for the jurors?
I just asked if there's any food allergies and we have more people that are.
Ah,
That's the first.
well, I don't. Well, I don't think we have. I'm not sure if that's gluten-free. Jesse Luxemberger? Hello,
Hey, Judge, good morning.
how's it going?
Judge, I'm blessed.
Yes. All right, if you'll make sure Christine Brown gets copies of that, please. All right, so today an offer was due. Were you all able to attend an offer?
Judge, we're in negotiations. I've conferred with Mr. Garahan. And Your Honor, I just would like a 1 month reset. We want to talk to our client, like, there's a chance we could work it out, and I'd like to just talk to him and go through that with my co-counsel.
All right, Ms. Ferguson. On this case, if you can give me a 30-day reset for a plea deadline date, please.
So Judge, even like if you had anything in early September, I don't know if you do.
Sure, I understand what's going on, counsel.
Thank you.
Okay, Ms. Ferguson, if you'll put this early September.
Yes.
That's perfect.
All right, and everything's gonna go well for you. I know it.
Judge, I'm doing my best to do my duty,
Oh, no, you know what?
and thank you for
The-
sharing.
Sure. You know, the key, they tell me you remove the stress, right? So it's gonna be fine.
Thank you. I really appreciate that. I always like the flowers too. It's good.
Hey, you know what? We gotta bring some beauty somewhere.
Amen to that.
All right. Thank you for addressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused.
Okay. Thank you.
No, it's a plea deadline date.
Thank you, Your Honor.
All right, thank you. Have a good one. What page is Luxembourger on? All right, thank you. I just skipped right over that. All right, and after this, no more, we need to take our break. Gregory Gonzalez Perneda. All right, that's gonna be 1:30. Because where did Nick go?
Judge. Oh, gosh.
Yes.
I have my protests on my property.
Okay, have you turned in your,
I turned it in a long time ago.
can you make sure, who's your guy?
I have two. I have Adam Keith. It's a discovery hearing, and then I have a plea and an MTR.
Okay, let me just tell you, I have none of those files. That's why I always say, if your name hasn't been called, it's because I don't have the files. This is all I have. So if you tell them to pull it.
I think they turned them in a long time ago, Judge. I've been waiting.
No, I'm telling you, this is all I have. let me just tell you what I have. I have Joshua Alcaraz, Roxanne Hutchinson.
Yeah, that's her. And Adam Keith is a
No,
discriminator.
I don't have Adam Keith. All right, Roxanne Hernandez.
Hutchinson.
I'm sorry, Hutchinson.
So I believe you have Adam Keith, Judge.
I go with what I have. That's why when people are sitting and they're staring at me, I'm like, why are they staring at me? I'm like, I don't have anything. All right, court is calling 2024 CR 007-949, State versus Roxanne Hutchinson. Can I have parties announce?
Megan Galloway to the state. People got from the defense.
And are you Roxanne Hutchinson?
Yes, ma'am.
All right, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Roxanne Hutchinson who was placed on community supervision in 2024 CR 007-949 for the offense of unlawfully carrying a weapon with a felony conviction for 7 years on November 7th, 2024? Is that you?
Yes, ma'am.
All right, state.
Yes. Are proceeding with violation of condition number 1 on or about the 19th day of February 2025 in Bear County, Texas. The defendant Roxanne Hutchison committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True. The state will waive and abandon the remaining violations, Your Honor.
Any objections?
No objections, Your Honor.
All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty. I'm sorry, grant the motion and sentence you up to 10 years in the prison
Yes, ma'am.
and up to a $2,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to proceed with your violation of condition number 1 in your plea of true?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it would involve the following case, which there's plea paperwork before the court for the same defendant.
Yes.
The state probation and believe defense's recommendation is to continue probationer on this probation in cause number 2024 CR 007-949, but to amend conditions to now include state ISF, cognitive track, followed by ISP. And probation did make a note upon disposition of pending cases, the plea paperwork on cause number. Well, I see at 2025 AL 002-862, there's a cause number I don't see right now, but those conditions would also reflect and run concurrent with this cause number.
All right, what has she done on probation?
Judge, the only thing that Ms. Hutchison has done on probation has been to provide her DNA sample as required.
She was recording, sorry.
She was reporting, she reported last May 7th of 2025.
She had been reporting previous to that as well.
Right, I'm saying her last reporting is on that date.
All right, so here's my question. Has she done her parenting classes? All right.
Judge,
Did she obtain employment?
Judge, if I may
Yes.
inform the court, she was doing the parenting classes through CPS. She has a CPS plan because she's trying to
get her child back through CPS. So she's doing the CPS classes through CPS. She has a CPS plan. So she's going through CPS. So she has a CPS plan. So she's doing her parenting classes through CPS.
All right, so how long has the CPS case been open? Was it open before this case?
Yes, ma'am.
So I don't understand why the court has received the new number one. She knows she has a CPS case, but she's picking up a new charge and she's not following through with the conditions of the court. I don't understand why I should follow the agreement to continue her.
Judge, I think she wants to
All right.
address the court.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Roxanne Hutchinson.
All right, why is the only tangent thing that I see from you is that you're picking up a new charge?
Hey, I know it doesn't reflect in the probation report or whatever, but since then I've kicked heroin. I've been sober for 9 months. I do admit that the issue wasn't me just getting sober. I got sober, but I was still doing the same things that an addict does. I was hanging around the same people. I didn't change my surroundings or my friends. So I continued to do the same things. I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
All right, so here's the thing. I don't understand why people don't think of their children before they pick up new offenses. I'm not following the agreement that you all have reached on this motion to revoke. I'm going to grant the motion revoke. Does anybody want to speak to time? She's looking at a maximum of 10 years.
Judge, we need to confirm.
All right, sure. Just have a seat. Joshua Alcaraz. All right, one second. Well, if this attorney's not here, just have a seat, sir. Okay. Just one second. All right, are y'all ready on Hutchinson?
On the switch, sorry.
Okay.
Do you want to give them some spray, Jack?
I don't know. Usually they have them in the restrooms automatically. When you walk in, it goes off. Sure. Sometimes it's never, my mom always says it's never the job. Sometimes it's people. And normally they're making it difficult with that ordering of things. All right, we're back on work. I mean, we're back on the record in 2024 CR 007949, State versus Roxanne Hutchinson. All right, yes.
Judge, I'm gonna re-urge the court to consider following the recommendation from probation and what the state originally wanted. Ms. Hutchinson is before the court. She verbalized that she needs help. She's asking the court for help. It's not often that a defendant is before the court and they are asking the court for some help. She is asking for help also with CPS so that she can get help from CPS. It's well known that addicts relapse. That's not uncommon. And that's what happened with her. And because that happened, she picked up other offenses. The state of Texas is willing to give her an opportunity. So I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to inpatient treatment so that she can get some help. That's what she's asking. And so I'm re-urging the court to consider that.
All right. The court, as previously stated, is finding violation condition number 1 true, and the court is going to grant the motion to revoke. Does anyone wish to speak to time?
I believe that we will be going open on that. The state understands defendant is facing up to 10 on this MTR. The other case that will be before the court shortly had thoughts. Basically, the state is thinking, we pled true to number 1, you're facing 5 or facing 10, state would ask for around 5, Your Honor.
All right.
Judge, we're asking the court to sentence Ms. Hutchinson to 2 years in TDC.
All right. This is what the court is going to do. The court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you a credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, please.
All right, so you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do y'all want to reconsider the plea bargain agreement with the theft case?
Yes. Yes, Your Honor.
All right.
I will get this done quickly, Your Honor.
All right, thank you. All right, are y'all ready on Gregory Perneda? I need this one filed. This does not have to be file stamped. All right. Court is calling 2025 CR 002-023, State versus Gregory Perneda. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Nick Aguilar on behalf of the Honorable Gregory Perneda.
And are you Gregory Perneda?
Yes, ma'am.
All right. You are here, you were placed on probation. My understanding from both parties, you're asking the court to reconsider his sentence of probation?
Yes, Your Honor.
All right, is there any objection to the court reconsidering the legal sentence that the court placed on Mr. Perneda?
No objection from the state, Your Honor.
All right, is there an amended plea bargain agreement?
Yes, Your Honor.
All right, and Mr. Perneda, did you have a chance to review the amended plea bargain agreement with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
According to that plea bargain agreement, the state is waiving and abandoning the repeat enhancement paragraph. They're asking that your punishment be assessed at 2 years in the prison. There are no applications, and there's to be restitution of $60 to the Bexar County Crime Lab for testing. Did you understand that to be the new plea bargain agreement?
Yes, Your Honor.
Defense and state, are you all both understanding that as the plea bargain agreement?
Yes, and the state did fail to write amended on top of that.
Thank you.
We may at this time.
Yes.
Thank you.
And we concur with that plea bargain, Your Honor.
And did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor. Thank you.
The previous stipulations that were entered into, are those being reoffered as well?
The state would, yes, Judge.
And we have no objection, Your Honor.
All right. So, Mr. Perneda, you were given probation, but it's the court's understanding that you were revoked. Yes. So therefore, that is the reason why you're asking me to be revoked from, not really revoked, but you're asking that this new plea bargain agreement be entered on your behalf?
Yes, ma'am.
All right. And so the previous probation, you were sentenced to 2 years, suspended for 3 years. So the 2 years is within the plea bargain agreement as far as your liability with time. Do you understand?
Yes.
All right. Are you ready to proceed with sentencing?
Yes, Your Honor.
All right, then the court is going to sentence you to 2 years in the prison. There's to be restitution to the Bexar County Crime Lab of $60 for drug testing, and the court will give you credit for any time served. Is there anything else with regards to sentencing?
Nothing from the state, Your Honor.
Nothing from the defense, unless they can just tell us, somebody can tell us how many days he has back.
The clerk will be able to do that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, and I'll request the therapeutic community. Good luck to you, sir.
Thank you, Judge.
Thank you.
May we be excused?
Yes. Bridget, are you ready?
Yes.
Pause for a moment.
No.
And I did.
Oh,
Thank you, Judge.
you're welcome. Yes. All right, thank you. And have you all changed the plea bargaining?
Yes.
All right, Ms. Hutchinson, if you'll come up. All right, the court is calling 2025 CR 005153 State versus Roxanne Hutchinson. Can I have the parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Richard Gossett for defense.
And are you Ms. Hutchinson?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there applications in this case?
No, Your Honor.
Ms. Hutchinson, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Ms. Hutchinson, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions as state jail felony?
Yes, ma'am.
Just one moment. Are you all waiving?
No, Your Honor, we are proceeding with the repeater to make this a third-degree punishment range.
All right, thank you.
Yes, Judge.
If you all could write the repeater on here, please. All right, do you understand if the state approves of the repeater enhancement paragraph, then this will be a third-degree felony. The range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call on the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Hutchinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1. And is she going to agree that she's been previously convicted for purposes of enhancement?
Once we get to the stipulations.
If y'all would check the box. You further agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. Your punishment is to be assessed at 4 years in the prison.
You're initialing this right now, Judge.
Thank you.
Our 2 initials will reflect that we.
All right, thank you. This will run concurrent with 2024 CR 007949. They were taking consideration 2025 CR 007240, 2025 PF 26020. There's to be restitution of $60 and to the Bear County Crime Lab in 2025 PF 26020. There's to be no contact with the complaining witness. Did you understand that to be your new plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Judge.
And based upon the plea bargain agreement that you all reached, the court has drawn a line through certain things. If you all could initiate those, please.
Certainly, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes,
And did you sign it in both places?
yes,
Because this plea, did you understand by waiving that, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Your Honor.
Then she offense is charged. How do you plead? Guilty, not guilty, or no contest? State any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objections, Your Honor.
And I'm sorry, to the enhancement, how do you plead? True or not true?
True.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And I'm sorry, and also the court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the recommendation of the ADA and run it concurrent with the motion to revoke.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. This is to run concurrently with 2024 CR 007949. State will take in consideration 2025 CR 007240, 2025 PF 26020, 2025 PF 26020. Restitution to Bear County Lab and the cause number 2025 PF 26020. And the court will recommend the therapeutic community. Is there anything else with regards to sentencing?
May the state just confirm that it was 2 cases that were TIC?
Yes, it was 2025 CR 007240 and 2025 PF 26020. I'm sorry, 26020.
If the state may tender to the court.
Yes. Thank you, Judge. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Yes.
And who is your other client, Bridget?
Adam Keith. But I think Ashley's is gone.
Well, I don't even, let me see if they've given me that file. Ah, she did give it to, yeah, she gave it to me. See, I'm sitting here, I'm waiting for files. All right, it's a beautiful day. Adam Keith. Counsel, where are you on discovery with this case?
Judge, we are missing EMS records. And I supplied the state with a USB. And I'm still missing 6 videos.
Plus 6 videos missing. And do you know if they have this in their possession?
Yes, they do, I gave them a USB, but it wasn't large enough.
Okay.
And then I went ahead and I downloaded it, and so I narrowed it down to make it easier. And now I'm just missing 6 videos. And I think the USB that they have should be large enough for them to upload it to that.
All right, Ms. Ferguson, can I have a 30-day reset for discovery? This will be the final reset for discovery. If there's an issue, then witnesses will need to be subpoenaed by the state.
I can do. August 18th.
All right, August 18th.
I'm out that week.
All right.
I can do the 15th, the 14th, I'm sorry, or the week after that. Okay.
All right, we'll see you back on August 14th. All right, good luck to you.
Thank you.
You're welcome. Jerry McGee. Don't hand me any more files, please. Is this for a motion to revoke?
It is just, he has some unindicted cases. I think the state wants to see if we can reach a reset so I can get a global file from all the pending cases that we have.
All right, and state, how long will that take?
Judge, if I can have 3 weeks, it is a total of 7 cases that I have to go through. That some of them I was looking through right now, and some of them do have evidence, but on other ones, I'm gonna have to reach out and then I'll confer with Mr. Witter to resolve all cases.
All right, Ms. Ferguson, on McGee, I need a 3-week reset.
August 7th.
All right, we'll be back on August 7th, sir. All right, thank you. Xavier Doxy.
Have a seat, sir.
And after Doxy, it will be Joshua Alcaraz, Matthew Luis Martinez, and then Ruth Gonzalez Payne. Those are the only files I have. Oh, no, I need a break. I think, yeah, I need a break. Deputy Laura is looking at me with frowns. All right, court is calling 2019 CR 9540 State versus Xavier Dante Doxy. Could I have parties announced?
Megan Galloway for the state.
Catherine Valenzuela to the defense.
And are you Mr. Doxy?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxy who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson intention to damage habitation or place of worship on December 13th, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 43 on or about the 14th day of May 2025 in Travis County, Texas. The defendant Xavier Dante Doxy did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, in that the defendant was unsuccessfully discharged from a residential outpatient treatment program in violation of condition number 43.
All right, let's go off the record for. Over the glass jar. All right. So to that violation, how do you plead? True or not true?
True.
And that is the only violation?
It is, Your Honor.
Okay. Did you understand by pleading true to violation of condition 43, the court could find it true, grant the motion, and sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 43?
Yes.
Court will find violation of condition number 43 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation, and 8 years in the prison. This is the defendant's fifth MTR, and he's just failed to comply with his conditions of probation, and so that's why we're asking for what we are asking.
Why isn't he complying with conditions?
Here, for the court's clarification, that one of the recommendations for probation on that form was that he be placed in state ISF with the cognitive tracks. Yes, it's the fifth NPR. He has successfully completed all of the programs that have been inpatient. He's gone to ISF, he's gone to SAC.
So why didn't he successfully complete this?
I believe, Your Honor, and this is just preliminary, what I believe is that one, Mr. Doxey has not been evaluated for the mental health component when he was younger. He did have issues with ADHD. He did have issues in completing tasks. When we talked about it immediately, he said he knows he needs help. He knows that aftercare is the issue for him. He's very good at completing what we ask him to in a program, but it's the aftercare that's the problem. And so it's making better decisions, and that's why we're asking for the cognitive track.
All right, so here's the issue. I think everybody knew that there were mental health issues if you're trying to burn down a church. So that's a given. Everybody knew that there were some mental health issues. So that is why I had him evaluated for McBioff at the very beginning. This is his fifth MTR. There is nothing else the court feels that the court can do for him. It's his fifth MTR. And I understand probation's recommendation, but probation's recommendation for some people who've been missing for 4 years is continue. It's like, where's this person been?
Right.
So their recommendation, I do take it with a grain of salt, but I do internalize what they're recommending. But it's his fifth motion to revoke. There's nothing else. I don't think he's appropriate for probation.
And we understand that would be difficult, and we talked about possibly working with the state and coming up with a number that would justify. I mean, he has roughly done 3 years in the course of treatment in inpatient and in jail, waiting to go to inpatient. And inpatient is not like, a walk in the park or a vacation. And I think he would like to address why he would like to stay on probation and what he feels like he would get out of probation and what he could do if you would wish to hear that.
I mean, if he wants to present a testimony to the court, I'm always open-minded. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Xavier Dante Dotson.
All right. Do you just want to give a statement, or do you want to do question and answer, counsel?
I think he can give a statement where he discusses.
All right.
Basically, Your Honor, I feel like the leniency that's been shown from the court is very much appreciated. And I understand my flaws, and I'm capable of understanding where I was wrong and where from another perspective, it doesn't look that good, but I know where I need help. I know where my strengths lie as well as my flaws. And I do believe with the cognitive track and the opportunity to set myself on a better path would be implemented. And I think that more structure is the key here for me, if I do say so myself.
All right, so let me just tell you this. I'm internalizing what you're saying. Here's the issue. I know that sometimes people do great when they have somebody in their life to tell them everything to do every day from the time you wake up and from the time you go to bed, right?
True.
But I don't have the manpower or the hours to do that. I don't have anybody from this court who can call you for the rest of your life to make you do certain things. So you had the first motion to revoke. You were continued. Second motion to revoke. You were continued. Third motion to revoke. You were continued. Fourth motion to revoke. You were continued. And now we are here on the fifth motion. There's just nothing left for the court to do. And each time that a motion to revoke was filed, each time whatever issue you were having, conditions were set to help you address that. Your attorney is saying that you need ISF. That would help you, the ISF cognitive. But you've already been given the MRT because the last attorney you were here with said the same thing, and the court addressed that with the programs and tools that I had to address that. And the MRT was to address that. So I just don't think you're a good candidate for probation. I wish there were more programs available where there could be a case manager automatically, somebody to check in on you at least once every 2 weeks or once a month, but I just don't have the manpower for that. So I don't believe that you're appropriate. But I will tell you this, I do appreciate your giving me some insight into you.
Yes, ma'am.
And that you understand where you've gone wrong. So his states you were requesting 5 years?
It's requesting the 8 year.
All right, so you're requesting 8 years. So probation, there any new cases or no?
Judge, I do not see any cases.
All right, the court is going to take into consideration everything that your client has with the mental health issues, the fact that we really don't have the programs or tools equipped to handle his issues. So I'm taking all of that in consideration when I give him his sentence. So I'm going to sentence him to 6 years in the prison, give him credit for any time served. There's to be no contact with Danielle Yorks, Yorks. And I request the therapeutic community. All right, did you review? Just one moment, I am so sorry. Let me find out. The court is going to find you guilty and revoke. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, here's the thing. When you're released from custody, if you can't find a place to help you with your mental health issue, if I'm here, you can come back and address that with me.
Yes,
But I would stress to you that when you're released, the first thing you should do is go to Center for Healthcare Services, okay?
Yes, ma'am.
All right, good luck to you.
Yes, ma'am.
Thank you.
And just for clarification, the credit would also include inpatient programs that he successfully.
Yes, I'll give him
completed?
credit for any successful inpatient treatment.
Thank you, Your Honor. We appreciate your consideration.
Thank you. Joshua Alcaraz. All right, that's gonna come back at a different time. Matthew Luis Martinez. Hello.
We're just requesting a reset. It's a first setting.
Let me find him on the docket. Matthew Martinez. All right. State, where are you on discovery?
My knowledge, everything's been disclosed, Your Honor.
Were you able to tender an offer?
I have, yes, Your Honor.
Sir, how old are you?
36.
All right, Ms. Ferguson, I need a 3-week reset for a plea deadline date, please. All right, once you sign, just have a seat. Once you sign the reset form, you'll be excused.
Thank you.
You're welcome. Who's here? Ruth Payne?
Present, Your Honor.
Hello.
Morning, Judge. How are you?
Oh, it's been a
Good
day.
afternoon.
Yeah, good afternoon.
Good evening.
All right, the court is calling 2025 CR 004178 State versus Ruth Gonzalez Payne. Could I have parties announced?
Duffy Hitlock for the state of Texas, Your Honor.
Chris Arce for the defense, Your Honor.
And are you Ms. Payne?
Yes, I am.
All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Payne, did you review the application for community supervision with your attorney?
Yes.
All right, are you applying for deferred adjudication or community supervision?
Deferred adjudication, Judge.
Did you review, because both are signed, that's okay. Did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you weigh the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Payne, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance penalty group 2 less than 1 gram as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and sentences you to more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call them the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Payne, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor, I have.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor. I did want to ask for the court's consideration on the $1,000 fine.
Okay. All right, state.
That is the agreement.
All right, did you review the waiver of appeal paragraph? Did you understand it? Sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 120 hours of community service restitution, and no driving without a valid license. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers States Exhibit 1 and all attachments at this time, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. Also, may I have an opportunity to
Yes.
speak on Ms. Payne's behalf? She's 58 years old, Your Honor. She's fully employed. She takes care of her elderly husband, who is 75 years old, who is a Vietnam veteran, who is legally blind from a stroke that he suffered. I wanted to discuss the possibility of early termination of probation, as we intend on getting all the requirements done within the next 6 to 12 months. Further, Your Honor, the $1,000 fine, as she is a sole provider, she's fully employed, but they're basically just relying on her paycheck. We're asking for that to be waived as well, Judge.
All right. So what is your employment?
I work for Brett Lawyer Insurance.
All right. And do you have any minors in your home?
No, ma'am, I don't.
So why are you doing this offense?
I don't know, ma'am, I can't.
I mean, well, what caused you to do it? And let me just tell you, the reason why I ask some of these questions is because you need to figure out why you are doing what you do so that you won't repeat it and that you can get clean and sober.
I have not smoked. I am clean at the moment.
Okay.
And I will be for the future. I will not smoke again.
May I speak on her behalf, Your Honor?
So what caused you to do this? What was going on?
I have always smoked.
What, this?
No, not that.
So why did you smoke this?
Actually, that did not belong to me. I had it in my purse and I forgot that it was there. I smoke marijuana. I do not vape though.
Okay. Does she have any prior history?
I can check on that.
Nothing other than a DWLI, Judge.
And how old are you?
I'm 58.
Okay. Do you have any criminal history other than this?
The state can confirm this.
Okay.
This is true.
Let's go off the record for a moment.
Be back. Around the corner, around the corner. Second. Go downstairs. Who's here for this? Don't even start.
And counsel, this is just something that I wonder, because if she doesn't have any criminal history, maybe this is not for her, maybe PTD.
I agree.
Okay. Council, if you all want more time to discuss it, we can come back at 2. Well, you can see.
It'll just be a couple moments.
Okay, no problem.
Yeah. Is this on the record or?
Oh, no, we're not. Here's the thing.
Oh, are you gonna take a break or, sorry, I didn't know.
Oh, no. All right, so this is what I will do. We're gonna go back on the record. The court is not, any objection to the court not sentencing the defendant today?
No objection from the state, Your Honor.
And you're waiving PSI and TAP?
Yes, sir.
All right, so as previously stated, the court is going to find there's sufficient evidence to find you guilty. The court will defer finding of guilt. When do you think your client will have items done to present to the state?
I would say 3 months, 4 months max. We've already been on it. It's just a matter of dealing with these smaller counties that these tickets are on.
I'm gonna tell
We
you.
get paperwork from them within the next 30 to 60 days.
All right, so I'm gonna give you a 2-month reset. After that, she's gonna be sentenced.
Understood.
All right, Ms. Ferguson, if I could have a 2-month reset for sentencing? Right, September 15th, once you sign the reset form, you are excused.
Thanks, Your Honor.
You're
We would
welcome.
be excused.
You're welcome.
Thank you, Judge.
You're welcome.